There are many matters. What is this big urgency about it tomorrow?
Pardon to mention, my lord.
My lord, one bail matter was fixed today, my lord. For appearance of the victim, notice was specifically it was fixed to 2 p.m. my lord today. Is
Today?
it possible, my lord? Yes. Victim is ready to appear, my lord. She is waiting in Keonjhar court, virtual court.
It is settled matter.
Yes, my lord. The not settlement. Victim has been turned hostile. 164 has been recorded. 164 settlement.
I have not called any victim to appear in the court.
No, my lord. It was earlier fixed, my lord, for today after 2 p.m.
It was already fixed.
Yes, my lord.
At 2 o'clock.
Yes.
All the
Pardon to mention, my lord.
Bill application dealt by someone, I don't know.
Pardon to mention, my lord. CLMC 2023 previous admission, my lord. Chronological mix.
Pardon to make a mention. CLMC 2027. Press.
Yes. Yes.
Item 41.
My lord, that matter, my lord, the interim bail, my lord, the petition for interim bail, that file with Mr. Maharaj can pass over. 41.
42.
Yes.
43. 44.
Case under section 457 and 380. Only because he has 18 antecedents, my lord's last date has asked me to file an affidavit. I have filed the affidavit, but it was not came with the file. This is the Xerox, my lord.
Where is the affidavit?
My lord, that was not came with the file, my lord.
Wait.
And all the cases are of the year 2016. He was on bail. He was again arrested on 2023. And out of
Let's see what are the allegations.
my only, my lord, they broke up on the. In all cases, he was on bail. He was arrested on 23.
All are 2016.
Oh, yes, all are 2016. And out of 18, one is the present case, item number 1. All the other are 2016. They broke up on the key of the Anganwadi center, took away 5 tray of eggs, rice,
Gas cylinder.
gas cylinder,
So,
rice.
the co-accused concerned, your lordship granted bail in a BLFL number of 851 2024, my lord. I'm not giving with the direction to appear before the IO for 3 months.
Petitioner is, let me give you the case. The allegation against the petitioner is, investigation is on? Or
No, man. Completed. 8 months inside custody.
investigation has already been completed and charge sheet has been filed. Charge sheet has been filed. Pursuant to the direction of this court, the petitioner has filed an affidavit in Australia stating that there are as many as 16 cases registered against him, which are similar in nature. All the cases have been registered in the year 2016, and he has already been enlarged on bail in all those cases. All those cases. He further submits that the co-accused in the present case has already been enlarged on bail.
BLFL number 851 to 24.
On
My lord, on dated 5/3/2024.
Mr. Maharaja, Mr. Ragada appeals for the state and submits that in view of the fact that the petitioner is involved in as many 16 cases.
18.
Sorry, 18 cases. A stringent condition should be imposed against him. 6 months every Sunday.
Obviously.
Pardon, my lord, item 43.
Passover. Passover will be taken up not at your sweet will.
My lord.
Passover means we have to eat.
45.
You come at your own sweet will and badge into the court and say that you take off your mat. You are a young boy. Why can't you wait?
My lord. Sorry, my lord.
Yes.
May I be permitted
45.
45.
On behalf of Mr. Jafarullah,
My lord, in this case, another accused, there are three accused persons.
Yes.
And my lord has adjourned to another case to 21st, third. 21 NDPS Act. 21, 21st.
Along with
Along with 1061 BLPL 24.
yes. Next 45.
46.
46.
Both the
Yes.
Pardon, my lord? Connected item, my lord.
Huh?
Connected item, lordship, সেটা আরো ডেট রে কইଥିଲେ যে তার দুইটা অ্যান্টিসিডেন্ট আছে
No, which item you are talking about?
45 my lord.
Okay, 45.
45 sub-item, my lord. Your worship urgent to 8/3/2024. Another matter, your worship urgent to 21st. Both let
All these matter will be taken up.
21st.
ସେଇଟା ଖାଲି କହିଥିଲେ ଯେ ତା ଯୋଉ ଆଣ୍ଟିସିଡେଣ୍ଟ ଅଛି
ହଁ,
ଗୋଟେ
ହେଲା।
4 ମସିହାରେ ଗୋଟେ 506 ମାଇନର ଅଫେନ୍ସ ଆଉ ଗୋଟେ ଅଛି ସେଟା 16 ମସିହାରେ ସେଇଟାର ବେଲ ରେ ଯାଇଛି କି ନାହିଁ ପଚାରିବା ପାଇଁ
Oh, you get it ready on that day. Okay, next.
46
Yes,
46
pass over.
47
Pass over.
48
Pass over.
49 50 51 52
The petitioner inside the jail custody since last 9/1/24. Initially, case was registered for offense 363 and 366 of IPC, and after recovery of the girl, the case was turned to 376(2) and a POCSO 6 of POCSO matter. There is a love affairs between a victim and informant.
56
Is there any indication that?
yes my lord indication and
Last week, man, since that bail matters taken up as item 1, 2, 3, 4 there, then all will come, my lord. They are thinking that
the code
noting is there, my noting is there.
noting is there always
But why can't they list it 1, 2, 3?
when the code for listing
It will taken up top of the list, my lord.
the code for the listing as per the system provides it doesn't provide grade to the top the coding system that is
lekha hai ji.
will be there is no specific
Next week onwards, my lord, the orders matter will taken up fast, my lord, in
No,
top
no.
of the list, my lord. So that will be better, my
No,
lord.
in the list there is an indication, but it can't.
And
be-
that is indication, my lord.
No, but it can't be listed as 1, 2, 3 because there is a listing coding.
My lord.
There is a technical problem.
My lord.
Yes. Yes.
56
56.
57 57 58
My lord, 454, 380, 34 IPC.
58.
58 madam
58.
Yes.
3/11/2023 जेल कस्टडी.
Hmm.
My lord, FIR रे मो ना नहीं को अक्यूज कहबारु पुलिस अरेस्ट करछि. मो पाखरु भी किछि जिंस
What is
सीज
the
हेई.
allegation?
I think 4 criminal similar.
No, what are the offenses?
Yes, 454 and 380.
How many cases?
4 cases. 4 similar.
What
सब
is the
तक बेल रे
allegation in
अछि.
this case?
सब तक बेल रे अछंती.
Okay, in this case, what is the allegation?
They broke down the house and entered into the house and taken away the household items. And similar type of offenses are there in the distribution.
Two.
They have mutual.
2 months, 3 months.
Yes.
For the FIR, petition is executed in the FIR also, allegation in the petition is that. Okay. Mr. Maharaja appears for the state and submits that the petitioner has similar, petitioner has criminal antecedent. He has 4 cases. Mr. Maharaj, 4 cases against
सब तक बेल रे अछंती.
Land Council petition submits that the in all the 4 cases the petitioner is on bail. Mr. Maharaj would like that Indian condition should be he submit that Indian condition should be recorded. 3 months you have to appear before the IO. Yes.
59
Pardon, my lord, item 56 and
56 and
Pass over.
57.
Pass over matter don't come. You don't.
Sorry, my lord.
Then you can't come at your sweet will and there is a procedure. You should be there in time. If the court can come in time, why not you? With the bail matters. I'll adjourn it to May if you don't come.
My lord,
See, the pressure of work you have seen, 100 matters we will take up, and you come at your sweet will and ask us to take up the matter.
sorry.
Sorry.
I am sorry, my lord. If you
If you don't cooperate, then I'll adjourn it to May.
No, my lord.
My lord, I am
We expect that some cooperation should come from that side also.
My lord.
My lord, I may also pardon, my lord.
Yes.
Item 47 move heavily order, sir. I am just unconfident.
It is pass over whenever it will come.
Well,
You got 59.
59.
Yes. 60.
60.
376D cities report, my lord.
59.
59.
CD call, 59 CD call for 60.
60. 61.
60, my lord, 3021B of NDPS Act.
61.
Yes.
Not 61 now.
60.
Yes. The pass over.
Pass over.
Pass over.
Yes.
Also, item 61, also may pray for pass, my lord.
Pass over.
Senior Pitamraj is leading in this matter.
Pass over.
62.
May I please? On the last occasion, Lordship has called for the
Yes,
case
it is
diary.
not there, 302.
302 CD.
Yes.
has been,
Yes.
Last occasion, Lordship has called for.
awaiting CD.
Only basing upon his own confession, he has been arrested.
CD
Well,
302 ta CD.
well.
CD call for.
63.
Lordship is,
Last order is reflect like CD. Either CD ko hai.
Lordship is fixing to 1 week or 2 weeks after.
You keep.
चिट्ठी करवा.
63.
Please, Lords.
Yes.
Lordships, last occasion to verification.
376 2N.
You take rest. I'll take immediately after. 63.
Statement ଅଛି କି? ନହେଲେ unnecessary
Yes, Kali.
Wait. Let
Yes,
us
yes.
take 64. Wait.
64.
Thereafter I'll take. Wait. Yes, 64.
Yes, yes.
64.
Somebody is there? Okay. Pass over.
Pass over.
Yes.
Your Lordships, yesterday matter is called verification for the
Yes, my lord.
Ah.
Examination, Lordship
Examination
directed to
matter.
take instruction
Ah.
whether actually he is going to appear in the examination. I have received the instruction, Lordship.
Examination there.
Yes. That is there. The examination will be held on following dated on 15/3
Starts from 15 and ends.
ends on 23/3/2024.
ତାକୁ interim bail କରି ଛାଡ଼ିବା
ଆଜ୍ଞା ତାକୁ interim bail
ମାର୍କେଟ ଉପରେ।
ଏଟା xerox କରିବେ।
Have you moved an interim application?
yes, sir.
Where is that?
Lordships, I number 183 of 2024
You have said that
for 3 months application for upcoming examination.
the petitioner is in custody in FIR number in connection to the Koda PS case number 5 of 2024 and the section 4. He is in custody since
11 January 2024.
petitioner the interim application. The petitioner in the application instruction says that that he appearing in the what examination is that appearing in the
So plus 3 final year,
semester
6th semester, your Lordships.
examination. In what is it? Sixth semester plus 2.
Plus 3, your Lordships.
Plus 3. He is a student of plus 3 science.
Arts, your Lordship, political science honors.
Second page is the description. Second page is the next.
Plus 3 arts. Plus 3 arts. Good. His 6th semester examination is scheduled from 15/3/2024, and it will be it will complete on 22nd,
23rd, your Lordships.
23rd March 2024,
Your Lordships.
isn't it?
Yes.
23rd March 2024. Therefore, we seek interim bail, interim bail. Mr. Maharaja verified the say fact and please on record the verified visual fact and got the written instruction which is there.
Instruction supplied by your lordship may kindly mention his name. Is below the signature and.
Principal.
Yes, 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 my lord.
Instruction published by principal by judge the college.
Yes. Yes. Yes, yes. That instruction your lordship may taken on record.
That is taken out.
Yes.
Taking into consideration the information. Facts, and submission to pass interim bill for the period of
15 days from the release on the day.
20 days from the date of so.
Something from 15 days.
Subject to for the things that are bond of 50,000.
Yes.
One purity of life.
Shall not leave the jurisdiction.
And shall not.
Yes. Yes.
Let's see urgent certificate.
Yes.
Urgent certificate.
Yes.
Yes.
I'm sorry, in fact, I was stuck off in the staircase. So 61 was passed over. In fact, there was a long queue before the.
Seniors have some.
No, in fact, my lord, I did not want to take a precedence over others. So I waited.
No, generally this court gives some precedence to the seniors.
Yes.
In that exception, you are coming. Right?
No, it's not like I always.
Anyway, 61.
I am always on time. Let it say dispute of purely civil nature.
61.
So there was a memorandum of understanding between the petitioner and some intending buyers for purchase of some land. It's a purely dispute, and there is a memorandum of understanding that this particular piece of land would be developed. Subject to the approval of the BDA, they would be allotted with the flat. In fact, there's some dispute came. Some third party, there's dispute. So that didn't materialize. An alternative site was also selected. They are signatories, 4 people. It's a memorandum I have annexed.
With all respect, my lord,
Just a minute.
no, on merit I'm not. Mr. Bhuya, Jagannath Bhuya is appearing for the OPID case. So this is OPID. So Jagannath
Hey, last time the
name ଅଛି Jagannath
The name is reflecting.
Jagannath Bhuya ଅଛନ୍ତି
that's correct, but there is
ତାଙ୍କର objection ନ
in
ରହିବ
custody. Somebody is in custody for last 1.5 months. But OPID is squarely not applicable in view of a judgment of this Honorable Court, Justice Panigrais.
That's
Section, yes, no, Supreme Court has already dismissed the criminal SLP.
No, that was pending.
No, that's it. It's a disposed of matter. Mahesh Swata, your lordship may kindly go through the judgment.
This is R.K. Patnaik said that they are pending courier.
So I don't think matter went to Supreme Court.
Still the dispute is there.
No, that is correct, Milord. I am not on that. Even if Milord, assuming that that is not there, Section 6, Milord. Section para 15.
What is the amount involved in this?
Amount, Milord, they say that 4 buyers are here before others have been paid in a phased manner. There is no dishonest intention of cheating.
Okay.
Number 1, I have given a chart also showing the payments. Milord, page
4.08 crores. 4.08.
No, that's a vague year, but nobody has complained except one, and one witness has been examined. That is,
What is the stage of investigation?
Investigation is going on. About 35 investors. They have invested there.
They say, but nobody has come forward before this. Say, and except 2 persons, others are in the legal. They are getting paid.
You have case diary.
No. I have instruction,
paid,
1
Milord.
page instruction.
I have
Get the
been
case.
paying.
Yes.
Those people are, last time also they took time for the case diary.
Let them get the case diary next week. I am keeping it.
Yes.
19th.
Only
19th, Milord, I have a, I am
tell me the date.
be outside.
You tell me the date.
No, that's not the Milord. That's subject to your lordship's
Yes.
convenience. Maybe on 20th.
20th.
20th. Milord.
20th case diary. Call for the case diary, and Mr. Bhuya's name should be reflected in the cause.
Bhuya name is there. That is there in the cause list.
Last time also, I think he was not there.
Yes.
You made a similar submission.
Get the case diary. Tell Mr. Bhuya.
Your lordship may say,
କହିଦଉଛି।
Tell it.
Yes.
So that time will not be wasted.
Not
Yes,
only two persons have said, if that is the condition, I will be willing to deposit that amount, 12. So, but others are being paid, nobody has any dispute. So I am, my lord, gradually, because they are not interested to take the flat now. So it's a understanding between the two parties. There is an MAU between the parties. So there is no question of any dishonest intention or the,
If,
that-
except these two persons, everybody coming forward.
that's correct.
On 20th and another.
That's correct, that's correct. Deeply obliged.
ତାଙ୍କୁ ପଚାରିଲେ ସେ କହିଦେବେ।
Item 1.
Item
1.
ନାନା ବେପାର ହଉଛି।
47.
47.
He was waiting. 47.
47.
Nobody. Which is your item, sir? 15. Then I'll just call. From 1 I'll.
15 and 24.
Okay, I'm just calling. Okay, 1. Anybody in the bail matters? Yes. Bail matters.
64.
Bail matters. No, one after. Again call. Pass over bail matters.
Yes.
Pass over bail matters.
Yes.
41.
41.
41 ଟା
41?
ହଁ ହଁ
No, next.
ଦୁଇଶହଟା ଅଛି ଅଛି
41.
41.
Password 2 PM कल
2 PM. Okay, anyway. 40. 40. Pass over, huh?
42.
Nothing.
43.
May I please, your
Yes.
lordship?
Hmm.
My lord, petitioner is custody since 23/5/9/2023.
Yes.
As per the prosecution
The
story,
idea of taking the bail matter first is so that at least my tenants can type it out and we can upload it.
Exactly.
That's the idea.
Yes.
If everybody is taking
May I say
password,
one
then
thing?
it's not uploaded. That's the problem.
My lords, may I say one thing? If the bail matters are listed at serial 1 onwards, my lords, this
That I
confusion
explore.
will not arise.
That also I explore, but there is a coding system in listing. So that can't be listed. That's what I got the information. Because of some coding system in listing, it can't be listed as 1, 2, 3. That's the problem. I asked that. Technology also creating problem for us what to do.
The message has been passed on to the bar. Next week onwards, it will be regular.
So you see, the idea is
Yes.
before 1 o'clock, if everything is over,
Yes.
at least the stenographers can type it out, and in the lunch time I can correct it and upload it.
Yes.
So of course, the liberty of people are involved. So that's the idea, to take it up. Otherwise, we can take it from 1, 2, 3. It may reach, may not reach sometime.
Yes.
That's another problem. Anyway, 43, yes.
may I please, your lordship? My lord, petitioner is custody since 23/8/2023.
Yes.
My lord, alleged offences are 379 and 344. 334 about
79.
379 and 34 of IPC.
7 number criminal antecedent.
My lord, out of the 7 number of criminal antecedents,
What have you stolen?
my lord, motorcycle and already recovered, my lord. 16, my lord.
7 cases.
My lord?
7 cases.
7.
My lord, as per the direction of this honorable court,
7 cases. For the petitioner allegation against the petitioner. Mr. Ragada asked me for the same submit that the petitioner had similar 7 cases against the petitioner and criminal antecedent. He had 7 cases registered against him. All the cases are on bail.
my lord, out of 7 cases, 4 have acquitted.
And that out of the aforementioned 7 cases, he has already been acquitted in 4 cases, and in 3 cases he is on bail. He is taking into consideration for those 3 months to appeal.
Obliged.
Yes.
46.
Last occasion, your lordship directed the learned government counsel to obtain the instruction regarding filing of charge sheet. And I have got the certified copy of the charge sheet with me. In the meantime, charge sheet has been completed.
Yes.
307 my lord deleted. 307 and other offense my lord. My lord, a charge sheet submitted against the petitioner.
FIR was FIR section Okay, 307 is
Deleted.
deleted.
After investigation. There is no.
Right, petitioner is used in the FIR number. After the allegation is the petitioner is after investigation charge sheet is required, deleting the
But in fact, my lord,
previous offense.
but in fact, my lord,
307.
in fact, 307, though 307 related, my lord, 420 is still against the petitioner. As because the accused promised the petitioner, son of the informant, to provide a land, my lord. There is the agreement between the both the parties, my lord. And the constitution amount is 17 lakh and 50,000. Out of that, 5 lakhs, 50,000 already been paid, my lord.
50,000 only.
No, 5 lakhs 50,000. That has been.
There was an agreement.
Settled, my lord.
Why don't you pay back?
They did not consider the agreement. There were two agreements were made. First of all, the
How much you owe?
please.
How much you are liable to pay?
देवा पूर्व से केस कर दो फाइल कर
Okay,
दो
now you tell me.
that I have taken instruction.
You
So
have taken in
they
any
can
Any
recover
admitted
through
factor.
other method. That is a civil nature. They did not provide money. They did not.
Get this matter to quash it, quash the entire proceeding if you pay.
Exactly.
That line I am thinking.
The petitioner is inside custody for more than 2 months. They violated the.
Dropping the offense at the 307. The petitioner has how much? What is the amount you taken?
5 lakhs
5 lakh 50,000 has been taken by the petitioner on the pretext of selling or alienating his land. Thereafter, another agreement was made. It was there was a condition in the second agreement
You have paid
that within 3 months they have to pay the money. Thereafter, land will be alienated in favor of them. But they did not pay the money, and the case was lodged by the mother of the executor.
Captain submits that submits that he make all endeavor to pay back the amount he has taken in lieu of the selling of the piece of land once he is on bail. The legal bill, so bail for those the petitioners shall comply with the undertaking given to this. Yes.
My lordship, can you pause? My lordship, item 42, can you pause over? Sorry, my lordship.
Already passed over. Second time. Yes, next.
Item number 46, my lord. My lord, the
46.
my lord.
Yes.
452, 307, 379 deleted.
Yes.
452 and 307, 379. 3 of this is deleted. Same part. Tinda is deleted.
You are appealing.
Yes. Tinda paid. 452, 307, 379 are not applicable to the appeal.
307 जो drop हुई थी.
452, 379.
452 and
379.
These sections have been deleted.
3 sections.
After
Okay. Next.
47. Allowed.
Allowed. But I have recorded his undertaking that he will make good the entire payment after release. Yes.
47. 48.
48.
My lords, I am for one of the bail application. That
Yes.
is Hemanta Dhir with bail 87 2004.
There are 4 matters, my lord. Subordination there, my lord. Some of the council now it was better 2 people.
2 people. Yes.
48.
48.
48.
49. 50. 51. 53.
Please, your lordship. I am there virtually.
My lord, this is a matter under section 376 and 6 POCSO Act.
Item number.
Which is not.
Professor Pradhan alleges that he was called by one Kanha Mahapatra Millards to take country liquor, and both of them took country liquor and chicken, and this Kanha Mahapatra paid for the liquor and the chicken with counterfeit currency, Millards. And when he learnt about payment having been made by Kanha with counterfeit currency and confronted that person, he allegedly abused and threatened him. I have been arrested on the basis of the co-accused statement of Kanha Mahapatra Miller.
No, my lord. My lord, there is a clearly mentioned there is no CD, my lord. As per rejection order, my lord, the fake currency notes have been seized from the accused petitioners and the one color printer and white paper of 80 GSM have been seized from the accused petitioner Santosh Bhoi, my lord, for this petitioner, my
My
lord.
lord,
So
I
the
also have colored printers. I also may be having 80 GSM paper millers. Will that make me a counterfeiter? And my learned friend is pledging from
Counterfeit currencies are also recovered.
no recovery of
my lord,
counterfeit
CD is
currency.
required, my lord, only it is only our rejection order
CD
is
is
there, my
not
lord.
there, let
CD
him
may be
say
called
it is
for, my lord.
not there.
Call for CD. Call for CD. Let us see. Call for CD next week. Call for look. Yes.
55, 56.
May I please, Your Lord?
Yes.
My lord, here the petitioner before my lord is in custody since 14/9/2022, being charge sheeted for the offences under section 302, 201, 120B and 34 of IPC, Your Lordship.
CD is required, my lord, CD.
20.
302,
You
201.
have not filed anything except the rejection order.
My lord, I do have filed the FIR, my lord.
Where is that? Nothing.
FIR is at annexure 1, starts from page 8.
Page 8 is the only bail application rejection order. That's all.
My lord,
I don't know what.
BLC number 1068. My lord, item 1068.
Yeah, that's what I'm saying. 1068.
My lord, probably
Can I tell you what you have filed? Page 5 is the prayer. Last page of the bail application. Thereafter, you filed the
No, my lord.
rejection order.
No, probably
And
that.
the
No, in fact, my.
and same rejection order is filed twice.
No.
And thereafter, Bakalan.
No, my lord. In fact,
No. It is there with me. No means what?
My lord, my bail application starts from page 1 to 7.
No.
And annexure.
This is not there. You have to correct it yourself.
Probably it
Just
must
check it
have.
out. There is nothing. No FIR. No nothing is.
My lord, BLPL 1068.
That's right, sir. 1068 only. I'm 1068. Just see the annexure says certified copy of the order dated 22/12/2023.
No, my lord. That is not my rejection order.
But you have filed it. What to do?
Probably it must have scanned some. My lord.
Okay.
My bail application
Just
starts from page 1 to 7.
One minute. What is the name? Because
No, my lord. Onek alias Brojes Bag.
something else is. Something else. Yes, something else. It's because this is 10. Tomorrow. It's wrong file scanned.
My lord.
Yes. Yes, next. Tomorrow.
57.
Next is same, my lord. Co-accused arises out of same affair.
That's listed next week.
No, my lord. It is the next item. Item 57. That is of co-accused arises out of
Tomorrow.
57 302, my lord, sir.
302.
Yes, let it come along with BLPL number 1018 of 2024.
That your lordship had posted to 22/3/24 awaiting case.
22 no, 23/3. 23/3.
Okay, 23/3.
23 is a holiday, your lordship.
Order ta mention kala wrong heitu order ta wrong heitu. It actually order ta mention is 23.
No, I have also. No, I.
Show me that.
I don't have. I physical. Check it. Bail.
Bail notice was.
ये ठीक है
Look, 20.
1 second.
1 second. सेटा किंतु
See back.
My lord, both the items 56 and 57. Both.
56, 57,
Both 20 seconds.
Obliged.
60.
Hmm.
64.
The petitioner has been charged with offense under my lord section 20B2C. My ground for bail is only your lordship's, my lord, besieging your lordship's conscience. He's in fact suffering from AIDS. So, and he's now in custody since almost a year, 3 months less
What
than
is the
a year.
recovery?
Recovery is ganja from
How
the
much?
130 kilograms.
Where you show me some document where you are suffering from it.
Your lordship, the rejection order does not mention that.
But you
But-
show me something on record.
May I pray for a report from the jail doctor? Because it has been.
Is it so? Then it's dangerous to keep him.
Yeah, that's admitted. It's dangerous to the.
Then counsel for the petitioner submits that the petitioner is suffering from AIDS and he is in custody since
24/6/2023.
Let the report be called for from the jail superintendent. 98.
এটা কোরাপুট
Koraput, huh?
কোরাপুটে এটা সেটা
Central jail Koraput. Rishi jail Koraput, what is that?
পোটাঙ্গি জেল কোন জেল পোটাঙ্গি জেল
You'll also that mention, you'll also give a free copy so that I can.
Any copy?
You'll also mention the jail name, Potangi jail. Potangi jail. Potangi.
Huh? 18. Just
free-
verify it.
Yes, खाली free copy दिला वो, I'll get it.
Dangerous to keep.
Yes, yes.
18th March.
Here.
Call for silver.
Yes.
Item 1.
Item 1, my lord, kindly not press, my lord.
Not this.
Item 2.
Item 2, my lord, I'm praying for passing FIR and charge sheet on basis of the compromise.
What is the offense?
Offense under section 363, 366, 376, and 6 of POCSO Act.
That case, my lord, after judgment.
Wait,
Acha.
adjourn it to first week, 8th of April. 8th of, yes, next.
Obliged, ma'am.
Item 3.
Item 3, my lord, can you take up 1 week after, my lord?
Again, what?
Item 4.
Item 4, my lord, 2 weeks after, my lord, kindly.
Item 5.
Yes.
My lord, the petitioner challenges the order dated 30/9/2023 as per Annexure 5.
Yes.
A very small prayer before your lordship. The petitioner facing trial under different sections of IPC and POCSO, your lordship.
323, 506, 34, 307, and 406 of IPC, my lord. Here, my lord, I'm challenging cognizance, after charge sheet, my lord, cognizance has been taken under section those offenses, my lord. Here, my submission is that, my lord, allegation of 354, 406 are totally absent in the FIR, my lord, and in the materials available on
What
record.
about the charge sheet?
Charge sheet submitted under those offenses, my lord. But the allegations, there is no allegation of 354 or 406, my lord. And so far as 307 is concerned, my lord, that allegation is also absent against the present petitioner, my lord. And I have also annexed the injury report, which shows that received two bruises, my lord.
You can argue.
At the time, coming charge, my
of
lord.
charge.
Not change, my lord, this one.
Here, my lord, difficulties, my lord.
I'll give you that liberty.
My lord, difficulties, my lord. Here, my lord, 307 allegation is not made against the in-laws, my lord. But they have to come to the sessions court because this is a case of 307, my lord.
That is, my lord,
That's the procedure.
They are not charge sheet under 307, my lord.
They have not, but there can be separate
And-
trial, my lord.
Is there any
Or-
chance of settlement?
That, my lord, I pray notice may be issued with his husband and wife, my lord. She has filed some 125 proceeding and other cases.
Any divorce proceeding, anything is pending?
Yes, my lord, family court proceedings he filed.
Pending. Who has filed? You filed or?
No, wife has filed.
Seeking divorce?
CRP filed, my lord. 125.
No, no,
Maintenance.
I'm
Maintenance.
asking about divorce proceeding has not been initiated.
Not
either by
initiated,
you
sir.
or by her.
No.
I'll just, we'll see, we'll issue notice, let us.
Madam.
Issue notice.
My lord, one thing I pray, I'm not pressing for miscase, my lord, but the matter is posted for commitment on 14, my lord. So your lordship may observe that I will
No,
sort what.
let her come, you serve it, let her.
My lord, at least I will sort for adjournment on these ground, my lord.
May seek-
That may be.
But the business, submit that you would be seeking adjournment before the court, in view of the fact that the matter is pending before the court. He may do so if so advised.
Obliged, my lord.
Item 7.
Try to settle the issue. That's the idea of move. Otherwise, you have to go and argue on charge.
My lord.
May I please look? I'm challenging the annexure 2 Miller. Page starting
Annexure
page
4.
Miller.
Annexure 4.
2.
Huh? 2.
2.
Okay.
Starting page 7, running page is 8 Miller. Relevant person.
Yes.
What happened in this case? I am the accused in 138 Miller. The complainant filed the 138. After filing of the complainant, I filed the petition for jurisdiction ground. Jurisdiction ground. On that, the court below has not described anything. Here says that kindly turn to the page 8 below. Third, peruse the petition as well as the case record. On perusal, it is found that 142 NI Act is implement the cognizance offense. In this case, cognizance already been taken on 28/7/2022. Furthermore, this court has no power to substitute its own order. He has not described or speaking anything about the jurisdiction, only says that cognizance has taken, so I have no power to recall my own order. This is the only substance, but he has not. Kindly turn to the annexure 1.
Why it doesn't have jurisdiction?
Hello?
Why it doesn't have jurisdiction?
Why?
Why the court doesn't have the jurisdiction?
Complainant present the check at the Duburi branch. Duburi branch is the jurisdiction of the Sukinda court. JMF से Sukinda.
What is the check amount?
Check amount is $150,000.
Why don't you pay and finish it up?
Hello?
Why don't you pay and finish it up?
There is some dispute between the A, but for
You have
that,
issued the check.
no, I have no objection, my lord, for that. But for the jurisdiction ground, Jaspur order have JMFC has no jurisdiction.
Forget it. Why
That-
don't you
that
pay
is
the
the-
check?
because
Why don't
if-
you pay the check amount? I'll quash the entire proceeding.
If
I'll quash the entire proceeding, I'm telling you. Deposit here, I'll quash it.
my whole submission, if he has no jurisdiction, he cannot try. The
If you want
proper,
to suffer the proceeding either here or there.
that's true, my lord, because for jurisdiction, if he has no jurisdiction, how can that is the proper adjudication, that
Okay, I'll
could-
issue notice subject to you depositing 20%. That is 143.
Then I will take instruction because only
143 you have to comply.
that is
Either
the
it's jurisdictional court or this jurisdiction or that jurisdiction. And you are trying to invoke 482. In any case, there is a statutory provision there for 143. You have to deposit 20%. Deposit 20%, I will issue notice. Otherwise, pay the entire amount, I'll quash it. This is the option for you. Suppose I'll send it to the right court. Again, that court will ask you to deposit 143.
Yes.
Deposit here.
and it is not a question of deposit, my lord.
But
Only.
in any case, you have to deposit.
I will take instruction.
What instruction? That's law.
Whether he will deposit. The question is
Subject to petitioner depositing 20% of the check amount. Check amount is
1,50,000.
1 lakh. Subject to the petitioner depositing 20% of 1,50,000. 1 lakh
50,000.
50,000. Bracket like check amount. issue notice to the opposite party. Written within 2 weeks. In the meantime, proceeding before JMFC Jajpur Road in ICC case number 321 of 22 is stayed.
No, only I pay 10% maybe because
How can I? No question.
only
20%
because
deposit. No.
only I pay
20% or I'll dismiss.
No, that's not. I only because of
That's the law. Why unnecessary? It's not negotiable.
your
That's the law.
lordship is vast power. So
No, vast power doesn't mean that beyond statutory power also I'll go. 20% you have to deposit in any case. Why don't you pay? You pay the amount, I'll cost the entire proceeding.
there is some
I get fix some installment. I'll call him and fix some installment.
15% maybe because of
20%. 20%. Yes. Yes, next. Item 8. Yes.
Last week, then the ODC directed my to take instruction regarding documents. My lord, documents are already been filed and that have been treated as the evidence, my lord. As per paragraph 8, my lord.
Para?
Lord, instruction today I have received, my lord. 8.
1 of 20.
Okay, that's not a wrong date. One जगह 3 लिखिए. हाँ बस my lord the 1.
3.
Instruction, my lord. I have received from the Superintendent of Police STF Bhubaneswar, my lord. He has stated in paragraph 8, my lord.
8, huh?
The document have been admitted into evidence by the Learned SCGM Sonpur on 14/12/23 with the objection. And a copies are from there, my lord, the defense counsel, and they have with the objection, they received the copy and
14/12.
14 बार.
How can it be filed where the case is pending here?
No. But since the petition are already allowed by 311, the documents were called for, the court below, my lord, sent letter to the
this point
for production of the documents, my lord. According to the all the documents produced before the court and that has been admitted as the evidence, my lord. Like evidence already taken on 14/12.
the question is, the same question was raised by Mr. Ponda yesterday. The document which was not part of the records and charge sheet has been filed. Case has been now under trial. 3 witnesses have been examined. After my lord may see the evidence of PW3.
PW?
3. Ranger. Range officer, my lord. Page 19.
19.
My lord.
Yes.
They are relying upon some documents that pangolin has been seized, it has been handed over, it has been released, this, that. I cannot produce the said pangolins, it has been released. The said, my lord, we see paragraph 11. My lord had also seen the occasion to see the same after.
I don't know the
The said videographs and photographs of the release of pangolin.
Which question?
Question number 11, my lord.
Page
20.
20. Okay. Yes.
The said videograph and photograph of the release of pangolin were submitted to the IO, which is not present in the record. The said photographs were clicked by mobiles of our staffs. I cannot say the names of the owner of the said mobile.
Was it a part of the recording charge?
That is the question.
That is not the charge sheet. For that reason, the additional public prosecutor, my lord, filed a petition to call for that record, my lord. According to the court, my lord, issued a notice to the IO submitted the same and that has been taken by the evidence in the court, my lord. And the defense counsel, my lord, he has also received the documents with objection. Without objection.
Definitely with objection.
With objection received document and that has been admitted as evidence, my lord.
When will cross-examine something?
Nothing which is left with
my learned friend knows this law. When we will cross-examine a particular thing and will brought out from the mouth of the witnesses, those who have been examined by the prosecution. And prosecution could know that this is the lacuna. Can it be patched up by subsequent documents? That document has not been given to us.
After this cross examination, you moved.
What you know-
Even with
My lord, I should not.
391 is
I
very
should
clear,
not-
my lord, at the time of appellate stage, my lord, the court
Yes,
has
yes,
covered
yes,
the
yes, yes,
culprit.
yes. I know. I'm quite
That is there,
concerned.
my lord.
I'm quite
And the
concerned.
honorable appellate court
I am quite-
time and again, my lord, held that.
I am-
the
see,
court requires, my lord, then court
Don't
can call
shout,
for the
Mr.
records, my lord.
Parid-
No, no,
Raghav.
don't shout it.
My lord, what is my question is, prosecution has got power to file an application under 311 to recall a witness, my lord, to substantiate the case. Then why my lord section 207 is there? My lord, may see section 207. That's right. If everything can be ignored, this procedural law should not be there, my lord. Madam, please. So, supply to the accused a copy of police report and other documents. In any case where the proceedings has been instituted on the police report, the magistrate shall without delay furnish to the accused free of cost a copy of each of the following: police report, the first information report recorded under 154, the statements recorded under subsection 3 of section 161 of all the persons whom the prosecution proposes to examine as its witnesses, excluding therefrom any part of the regard, the confessions and statements, any other documents or relevant extract thereof forwarded to the magistrate with the police report under subsection 5 of section 173. Provided that magistrate may, after perusing any such of a statement as is referred to in clause number 3 and considering the reasons given by the police officer for the request, direct that a copy of that part of the statement of such.
Mr. Ragada, show me the application moved by the prosecutor to bring on record this document.
They have filed this petition, my lord.
Let me kindly see Annexure 2. Annexure 2 is the objection filed by the petitioner before the Lord Resident Sonpur, my lord. Paragraph 5. Please don't disturb.
The further PW3 is an official witness.
Annexure 2, page 9, paragraph 5. PW3 is official witness and had been produced those documents to the IO. He certainly have submitted the same before the court at the time of submission of charge sheet. Further, the seizure list available on record does not show that those documents and CD was seized by the IO and the PW3 had submitted the same before the IO. He certainly have seized the same and would have prepared the seizure list. But the documents available on record does not whisper a single word regarding the seizure of the documents and CD as pleaded by the prosecution in his petition dated 16/10/2023.
You tell me, Mr. Ragada,
My lord.
this
Page 8, my lord.
Under what provision? Which provision you have?
No provision is there.
Though no provision mentioned, my lord, but
You tell me support, sir.
My lord.
Support your case.
My lord.
Under what provision you have resorted to this procedure?
Though the petitioner filed, my lord, to call for the certain report, my lord.
You tell. You have
But
to tell me the
any time, my
procedure.
lord, 391 is there, my lord, appellate court also, my lord, the has the liberty to call for certain report at the record, my lord.
No, the court has not called for it.
My lord.
It is you
My lord,
who has moved the application.
My lord, move the application thereafter, my
Under
lord,
what provision you
allowed, my lord.
You just tell me
My lord.
under what provision you moved.
Simply, my lord, file a petition to call for the records documents.
What
my lord.
provision? There should be some
My lord.
procedure. Not that in the criminal trial,
My lord.
you have moved some application.
My lord, my lord.
Innocuous application with a prayer.
My lord.
And the IO comes to the witness box and says these documents were never seen, never a part of record.
My lord.
And you want to introduce some document,
My lord.
you have to follow some procedure. What procedure you have followed? Under what provisions of law you move this application, which is objected to by the. You just tell me. So that
91, sir. 91, my lord, the summons to the procedure documents are the things, my lord, other things, my lord. Whenever any court on any officer in charge of a police station consider that the production of any documents or other things is necessary or desirable for the
91 is not applicable to a trial.
391.
391 is additional evidence.
Let it complete.
91. Consider that production of the any documents, other things is necessary or desirable for the purpose of any investigation, inquiry, or trial or other proceedings under this code by or before such court or officer. Such court may issue a summons or such officer a writing order to the person in whose possession or power such documents or things is believed to be requiring him to attend and produce it or to produce it at the time of and place stated in the summons or order. That there, my lord.
Yes, next.
Any person required under this section merely to produce a document or other things shall be deemed to have complied with the requisition if he causes such document or things to be produced instead of attending personally or produce the same. Nothing in this section shall be deemed to affect section 123, 124 of Indian Evidence Act and our bankers. My lord. But the court has the power, my lord, also. The court issued a letter to the concerned IO to produce document. Accordingly, the IO produced the said document, my lord. That has been marked in the court, my lord, with objection by the defense counsel, my lord. Nothing more with left with the here, my lord.
When the document has been produced and I am not admitting, the minimum procedure is to give an objection, my lord.
They have given an objection, my lord. The lower court, my lord.
My lord,
With the objection that
the application.
This case.
Yeah, listen, let me complete. Why you are always? My lord, here is a case. An application was filed after the examination of PW3.
Yes.
After the examination, if I would not have put these questions to PW3, then my lord, this application which was filed under Annexure 1 by the prosecution would not have, yes.
Might not have come.
That would not have seen the light of the day. My lord, is it the law, my lord, that when a document is not there as a part of the record and that has not been given to us under 207 as required under the statute, they can do so at a later stage by using section 91. Section 91 is for a different thing, my lord.
Where is the bar?
My lord?
Where is the bar?
That I'll show that. The 20, my lord friend will misconstrue section 2 because 207 is mandatory. I was arguing a case before division bench. Honorable Justice.
There is a bar, then I'll.
Yes.
That happened, my lord. In fact,
no, I'll show that happened. Why is that happened? Second of tomorrow.
The moment the defense counsel, my lord, accept the document.
With objection.
The objection, my lord. They can raise at the time of argument that point, my lord. There is nothing left to the petitioner to raise this petitioner with their, my lord.
When the order was passed,
objection.
Order was passed on 212.
Pursuant to the order to this court, Mr. Ragada, place on record the written instruction dated instruction dated 12/3/2024 issued by the Superintendent of Police, STF, Bhubaneswar, which is taken on record. Matter partly heard. Please also.
One thing, my lord, first, my lord, I have mentioned CRMC 3 of 2024. One of
correction code.
And
you show me where. Let it be 3rd April. 3rd April.
Till that day, ballot trial may be stayed, or else it can be taken up early because IO is to be examined. Ballot, it was posted yesterday.
Tomorrow, tomorrow, ballot can take.
Tomorrow.
Tomorrow.
Let it be 15th.
Not 15th. 15th ballot. Good many cases have been posted. 20th.
20th.
Okay. If case, I don't know. It was posted yesterday. IO has not been examined. Let his examination be default.
This you tell them not to. And even if it is examined, how does it make difference?
Yes, that is
no difference.
Because again that will be legalized. The document which they have given, before examination, that shows the hurriedness of the prosecution. The IO has not yet been examined. He was about to be examined, but they produced the document apprehending that the court may state.
The only question is today, the documents which were taken on record with objection, if there is a bar.
No, my lord. The objection is, my lord, whether a document can be produced.
Then you show me that.
Yes. It can only be produced before trial. These are the admitted documents. There is specific provision in CRPC for that. But here they have given it behind our back
You have invited problem by asking the question to.
No, my lord, it's the duty of the defense, my lord. It's the duty of the defense
My lord,
to.
only to
Anyway.
delay the proceeding, they have filed this
Anyway,
petition.
Anyway, it is on 20th. Next.
If I was examined, my lord, nothing.
Let us see, let us see. Let us see what the document.
15 and 16.
Yes, 15, na? He's waiting for a very long time.
May it please your lords.
Yes, 15.
DB case petitioner is the aggrieved person wife. DB case was filed on
Yes.
17/12/18.
Yes.
It is not yet over. Examination of PW1, the aggrieved person took more than a year because on flimsy grounds time. My prayer is let it be disposed of, the case be disposed of with a particular period.
Who are
As
you?
I am the aggrieved person, the wife, in the DB case.
When you filed this DV case?
DB case was filed on 17/12/18.
18.
My lord, that is still continuing.
What?
My prayer is that let
Any
it,
interim order you got?
no interim order is there. My prayer is that your lordship may direct the,
I understand, but we have issued notice.
no, once notice is issued, again it will be infructuous because it will take time. Your lordship may grant any time, let it be disposed of within that period.
Yes,
whatever.
Mr. Maharaj.
Yes, yes.
See, 2018 DV case, not moving at all.
Yes.
No interim order.
I'm sorry.
What to do?
Item 21. No,
15. मुझे DB का जल्दी सोल्व करते फटाफट की my lord decides
Year of the case.
18.
2018.
Yeah, lordship can be done. Dispose of the case. Let
Man.
Can be.
Without issuing notice to the.
Notice not necessary. It's a dispose of case.
Yes.
एक चाहूँ कि तब वो limits
Again.
dispose of. So only to dispose of.
Yes,
Petitioner, has moved section 12 application.
My lord.
Where is that petition?
That I have given, my lord.
No, where is that? DB petition.
DB case number is 326 of 2018.
Where is that application?
Application is not here. I have given the entire order sheet. Your lordship may kindly turn to page 18. Order dated 17/12/18.
No, just I want to know whether you are seeking time or
I have given the entire order sheet.
where is that?
Annexure 4 series.
Either petitioner moved an application under section 12 of PWDV Act in the year 2018.
Wait,
18. However, the matter is prolonged since then without any interim order. The Learned Counsel for the petitioner is relying upon the proceeding for the court below in the DV case. Perusal of the proceeding indicates that the delay so called disposal of the application under section 12 of PWD Act moved by the petitioner could have been avoided. Without going into the details of the reason for which the proceeding was held. I am of the considered view that taking into the consideration the long pending of the present case, the trial court should do well to see that the proceeding is concluded as early as possible, preferably within a period of 6 months.
Yes.
6 months.
Well,
6 months.
Yes. He has another matter 24. He has another matter 24.
Yes.
I am challenging that.
Hmm.
Your lordship may kindly see the grounds.
You are the husband.
I am the husband.
Yes.
Your lordship may kindly take into consideration page 6, my lord.
Yes. 6, huh?
Page 6.
Okay.
In the appeal, the last ground, I have other grounds I have raised, but the last ground may kindly be seen.
Yes.
I,
Ah.
that it is evident from exhibit D 8/9, which is self-signed declaration made by the aggrieved person before the Kurmingia villagers and her relatives on 22/10/2011, that she had no relation with Ravenshaw Nayak, the present appellant, earlier or at present, which showed that the aggrieved person has filed a vague complaint against the appellant opposite party with some malafide intention. The next one, it is evident from the evidence of D5 and 6, who are none else but the neighbors and maidservant of Samson Naik, who was a Christian preacher, that the aggrieved person is the wife of one Samson Naik. These are the grounds on which, main grounds on which appeal has been filed. And in the appeal stay has been rejected.
Where is that rejection of state?
My lord, Annexure 1, the order passed by the learned appellate court.
6/1/2022.
Yes.
Yes.
Application filed by the husband. What is the judgment?
Judgment is for
9/8/2023 judgment.
my lord, judgment is for 7,000 and 2,000
7,000?
per month, my lord. And the petitioner belongs to Hindu community. The present petitioner, the aggrieved person belongs to Christian community. So there cannot be any
But
marriage.
you say that there is no domestic relationship.
My lord,
Therefore,
there is no marriage.
As per the evidence of.
Yes, my lord. I have also laid evidence with documentary evidence.
Against other to man.
Court court under affidavit.
She is 60-year-old agreed person.
My lord. After retirement in defense, he has been arraigned.
What living in relationship?
Not live in, my lord.
What is that?
He has not married her. That is his case.
Then I have to issue notice, let us see. Because in any case, these are maintenance. Notice issued.
Unless some entry order is there.
Entry order is only for paying maintenance.
My lord.
You keep on because she 60-year-old woman. The findings are she is unemployed and has no income. And all. So therefore, maintenance staying is not possible.
From no, let there be payment from today onwards.
Or you keep on paying subject to
From today onwards.
up to date.
From today onwards.
Arrears.
No.
Where is arrears? Arrears, there is no question of arrears. What interim order you want? It is your appeal.
Stay.
What interim order? I can't say the appeal. Appeal has to.
Your lordship may kindly issue notice by special messenger.
Nothing.
Special
No, they
messenger.
can be-
No, your lordship may kindly issue notice by special messenger and fix a particular date.
Yes.
So that it can be decided on that.
Yes, special messenger.
And if there is any mediation or there is any settlement, that can be done also.
Yes.
Mal.
Okay. Notice to the opposite party number 1. Mr. Maharaja accept notice for the opposite party number 2. Special messenger and for the.
A date may kindly be fixed.
Huh? First week April record.
Tarikh to fix.
Third.
Mal.
We will send to mediation and pay some.
Mal.
Yes.
That is agreeable.
Yes. President sir, photo. President sir.
10 items. Next item.
Yes. Next 20.
Not.
Item 9 members is 10.
9 is
9.
Item 9 is next. His item is 10.
No, okay. 10.
Okay.
Yes.
I'm obliged. Yes, my lord, where I filed this application against an order where the Sessions Court at a belated stage has altered the charge under section 216 of the CRPC. And the main ground of attack is on the basis of a affair lost by the father of the victim, lady, my lord, which has been filed here with its annexure 1 at page 12. Your lordship will find that the allegation is his minor daughter was kidnapped. Subsequently, was detained by the two accused persons, and she was raped. Thereafter, my lord, the case was registered.
Who are you? Who are you?
I am one of the co-accused, and the principal accused was kidnapped, my lord. I am his friend, and the allegation against me is, my lord, I have also joined him, my friends, in committing the rape on the victim girl. That is the allegation against me. That allegation was there in the FIR, in the 161 statement, 164 statement also. But there is no charge under section 376D, my lord. There is a charge under section 376N, continuous rape, my lord. 376D is gang rape. There's no charge initially for gang rape, my lord. But subsequently, he altered the charge during time of alteration of charge. While this order was passed, I produced my lord, a copy of the RTI obtained from the RTI, showing that the victim girl, who was alleged that she was detained in a house, dilapidated house, or she was given shelter in a house.
CRP's petition, dispensing personal appearance, my lord. And my lord is arising out of a 1cc case of 138 NI Act, my lord. So lordships, usually my lord 205 petition allowed by every court, including my lord magistrate court, my lord. But my case that had been rejected, my lord, therefore I pray lordships. Annexure 4.
Why can't you appear?
My lord,
Why can't you appear?
my lord, petitioners, my lord, present the petitioner, my lord, who is Andhra Pradesh, my lord, staying permanent resident in Hyderabad, Andhra Pradesh, the address is annexure and file, my lord. The petition is called 1cc petition. And Rayagada is the court, my lord, where, my lord, this order has been, 205 petition has been rejected.
What is the check amount?
Check amount, my lord, that is, gote hoji lakh tanga, gote hoji 3 lakh tanga, my lord.
Payment kari khatam karo.
I guess khatam karo, that is the, my lord, intent of this act, my lord. I will also, my lord, cooperate, my lord.
I'm issuing notice to you.
Again.
Simply issue notice. Simply issue notice.
My lord,
the amount is not big, so I will not say.
My lord,
On CC case in 205, how can I say it like this?
my lord, 205 petition, my lord, will compromise I'll compromise, my lord, every petition, but
Come with the money, I'll pass it.
money, my lord, say 80 stage my lord, lordship kindly have a glass.
No question of 138 matter. The statute provides that it has to be completed within 6 months.
My lord,
20 application is rejected, therefore I will have to stay the proceeding. What are you talking?
na 10 my lord. Notice issue kar 5 din samay de do, 5 din both the party will appear, my lord, before lordship, my lord, matter will be.
No, I'm giving a short date.
But date over date no apart my Hyderabad se asi date no, my lord.
I'm giving a short date.
Process,
let him appear online and pay the money. We'll pay.
Next, my lord, discussed further state say till that means jo din apanta apna say din apanta
No
lordship
question. In 138, no question of no question of stay in a 138 proceeding. Once you have admitted the check, you.
My lord, last occasion I argued before lordship, my lord, 8/2/2024. Your lordship, my lord, directed me to appear before BC.
You appear with this.
On that observation, my lord, I took time.
I'm aiming at settling with this.
I am in favor of my lord lordship.
The amounts are very less. 1 lakh and
3 lakhs.
3 lakh.
My lord.
We can persuade the complainant. You can pay by installment and pay.
My lord, BC ପାଇଁ ମତେ କହିଥିଲେ ମୁଁ କହିଲି ମୁଁ ଆଉଥିଲି ରାଇଟ୍ ଡେଟ୍ ଭିସିରେ ଆଫିୟର କରିଦେବି ଲର୍ଡସିପ
ଆସୁ ନା ସେପଟ ସିଏ ଆସୁ କମ୍ପ୍ଲେନ୍ ଆସୁ କମ୍ପ୍ଲେନ୍ ତ ୱିଦାଉଟ୍ ହିୟରିଂ ଏକ୍ସ ପାର୍ଟି
ଲାଷ୍ଟ ଅକେଜନ ଲର୍ଡସିପ ମୁଁ ଟାଇମ୍ ନେଲି ଆପଣ ଦଉଥିଲେ ମୁଁ ବୁଲିଲା ମୁଁ ଟାଇମ୍ ନେଇ ପଳେଇଲି
that is bad luck.
ସେ ବେଶୀରେ ଟିକେ କରିବ ହାଇଦ୍ରାବାଦରେ ଟିକେ
Keep on changing what.
My lord, ମୋର ବ୍ୟାଡ୍ ଲକ୍ ମୁଁ ସେନା ଆଡମିଟ୍ notice may be split for notice by the district court as the lordship directly
bring.
Again, I'll tell them, my lord. Say go to
Next.
that is a no action, I may permit to my lord move that this case.
Is against the rejection of an application under section 457 CRPC for release of the bank account, the amount standing in the record. The actual matrix leading to the filing of this application is that the present petitioner is a doctor serving in the government hospital. A case was instituted against his father, possession of disproportionate assets. The father is a public servant. The petitioner is not with the father serving elsewhere. He has 2 accounts in the bank. One is a salary account and another account in HDFC Bank. whereas he has transferred some funds out of that account to the other account. Both these accounts were put on hold seized by the Vigilance Department after this charge. The petitioner moved an application before the learned trial court, maintaining that freezing of these accounts are not permissible in law, it's not an accused even in the case. And the learned court permitted the petitioner to operate the accounts, but the amount standing as on the date of the house search has been kept as such, and the petitioner is not permitted to withdraw that. Now, my humble submission herein is that the Honorable Apex Court, in a case similar to this nature, has observed that the law provides for an attachment proceeding. There is a procedure in the law for attaching the properties. And the Honorable Apex Court further says that while you are searching a house under Section 102 CRPC and effecting schedule, you cannot hold up the bank accounts cannot without moving under the law and obtaining the necessary. No reasoning the trial court has kept the amount as such. Yeah,
Prior to addressing the issue, Lordship can see the certificate has given the wrong certificate and not mention the earlier case numbers. Earlier case number, chairmanship 241 of Chabisi, chairmanship 243 of Chabis. In respect of what is father and mother, that has no certificate has been given. And
They have moved application.
they have moved it, if you are, and your lordship has urgent it to some other date, let it come along with that. I'll take instruction. So the point of law is concerned, I am not agree. So what 457 is concerned, it's an application rejection of 457, which is revisable. So 482 will not be applicable.
Lordship, only one thing I am pointing out. My learned friend pointed out that two other CRLMC applications are filed and there is no certificate in it. That represents like the father is an accused, the mother is an accused, and the son's account has also been created. All these three CRLMC applications were filed in one day. One day. And they may be tagged. I don't have any problem.
Lordship may call it along with that, that application.
And as a short date, Lordship.
Do not because it was no. Already order he said. I'm chairmanship 241 of WC, chairmanship 243 of WC. Along with
Your short date.
short date, you not date even.
ନାଇଁ ନାଇଁ ସେଇଟା ଯୋଉ ଦିନ ଥାଉ ଏଇଟା ତ ହଉ ସେଟା ଆସୁ କା ସାଙ୍ଗରେ
ଅଛି ତା କାରଣ ଅଛି ମୁଁ କହୁଛି
ନାଇଁ
ଅର୍ଡର ହେଇସାରିଛି ତିନି ଜଣ ଏକଥରେ ହିୟରିଂ
We'll see.
ମାନେ
Okay. Item 12. Good.
No, the matter has already been compromised. And this opinion number 2 and 3 filed their compromise affidavit. That has not been came into record. That was filed on 9/2/2024. I pray.
What are the offense?
The offense, your lordship.
376.
That is not against me, your lordship, and the one of the accused so far the opposite part number 3. They solemnized their marriage, living together as husband and wife. And allegation against me that I was
What is the age of this lady?
now 31. And the occurrence time was 2009. By the time
Bring them.
and sir, being a date may can fix in the meanwhile the affidavit may can be came to record, your lordship. A date may can be fixed, your lordship. Coming Wednesday, your lordship.
Before that, your lordship may kindly see the gravity of the offences. Question is, he is not setting the compromise not there between the accused and victim. And it's a segregation that they are living separately.
No, the question living separate, they are living together, your lordship. The man accused.
Why he is not a party to this?
Yes, exactly.
Your
My
lordship,
point is that
they stated that so far my client is concerned, he stated they are unable to come High Court and approach because they are possessive of funds, and the wife is ready to come here and file affidavit.
Wife is ready to come and file affidavit so far as you are concerned. But she doesn't want to come and file affidavit
Because they are your lordship.
in favor of the husband.
That your lordship, they can explain why your lordship they are not coming, your
Why
lordship.
should I ask for
Because so far
example?
my case is concerned,
It is a fact that matter has been compromised. They came and filed and compromise affidavit.
But
Let it make
ठीक है।
that make and fix your lordship.
से केसटा तो ट्रायल होगा ना
हाँ।
से केसटा
Husband will face the
Lordship, I have cited judgment, your lordship partly can be quashed, your lordship.
partly can
Partly
be
Can be quashed, your lordship.
no, don't go.
Your lordship, judgment of our own High Court.
Who says it can't be done?
Yes, my lord.
The
The
settlement
376 is not against me. I am not the accused of a
question
376
is
is
the
concerned.
settlement is doubtful.
Yes.
Your case is the main accused who is facing the trial under 376 has married with the victim. I am a co-accused. I have settled the dispute with the prosecutrix, that is the victim. So therefore quash the proceeding. If the settlement has taken place on the premises that the prosecutrix has married with the main accused, why main accused is not coming forward for the settlement?
That can also explain if he will appear before the court, your lordship. Let the matter may kind of take up some of the day, lordship. If in the meanwhile they men came, it may be developed, your
It
lordship.
can be quashed the entire.
Yes,
FIR,
yes,
both
yes,
the
my lord.
accused
Yes,
can
it
be
was
quashed.
from the day
Yes,
my, before filing this application, it was also my suggestion to my client
Right.
to bring all of them. So he stated that is honorable because some other accused person staying outside of the Odisha for the purpose of their work.
To only the idea of quashing the FIR is to save the marriage of the prosecutor.
No, no, both
main
my lordship, there
Only-
there
only
is
that
no
is
doubt
the
about
idea.
That is why
your lordship,
your lordship is
there
intervened.
there is
Anyway,
no
give a date and bring them.
your lordship coming Wednesday, your lordship coming Wednesday.
Till now, my lord, other co-accused are under the ABLPL, my lord. It is pending also, as per declaration by Leonard
This is
Frank.
doubtful, this lead.
No. This is wrong information, lordship. They were on bail, your lordship.
How many accused persons are there?
There is like
Five
five accused person. They all were on bail except me, your lordship. Let the camp
But
this.
he is only interested to drop the case against you.
No, not interested. He is interested to drop the case against all your lordship because all other
see,
not
Asankar can
appear before your lordship. Therefore, this application is
Let it
filed.
come, there is something.
Yes, ma'am. Let it come, your lordship. I have no objection. Let it come. I have no objection, lordship. They will appear before your lordship.
Pending or not?
Coming your next day, lordship, 20th.
No, 20th, not possible. First week, April. Third or fourth. Fourth.
Apply yours.
Yes.
8th amendment kari
Item 13.
20th, your lordship. 20th.
Fourth April.
In the meanwhile, the affidavit filed by the informant and so far the victim that can be recorded.
That will come.
Aye.
Yes.
It will settle, your lordship. My friend is saying that it is theory, sir, but it has been settled and that has been settled by
You
he
bring
himself.
all the accused persons who will quash.
No, your lordship, that
In
question, your lordship, whether it has been partly quashed or not to be passed because there is another question of law, your lordship.
It's not.
I
there is
am,
nothing
I will
question
take
of
steps,
law.
your lordship, I will take steps to bring all the accused person, your
Whether
lordship.
this
in
lady
my
is
ability.
extorting money from all the accused.
No, I have no money. The
Government
question, no money at all, your lordship. The question, no money
He's
at
not
all.
interested to quash.
Because they are living together as husband wife, they have also an issue, your
All these things are
lordship.
doubtful. Let us-
They are doubtful will clear when they will appear, your lordship.
He should come.
Oblige, lordship.
My pleasure, Honor. This
Yes.
is the case under section 498A, criminal case, and in the meantime, the matter has been settled between the parties.
Call
Both
them.
parties are residing jointly as husband and wife with the
Call
petition.
them. When can you call?
Call them.
Tomorrow?
Tomorrow, the 19.
19 at 2 o'clock. If they can't come through VC.
Yes, my lord.
That's
They will call.
Yes. Item 14.
May I please, Your Lordship? Thank you. There is a question of the entire criminal proceeding against the accused petitioner who is facing trial under section 3762N and 328, 313 and other offences. The affair was lodged under
Charge sheet
section
filed.
charge sheet filed and 3 witnesses have been examined in the court below. FIR was lodged by the brother of the victim under section 417 and 493. It was allegation was made that there was a love relationship between the victim and the accused persons 3 years back, and the victim, the petitioner, gave a proposal to the victim for marriage, and there was a physical relationship made between them, and after pregnancy of 9 months, she delivered a still baby in SCB Medical College Hospital. After delivering the still baby, after 5 days of delivering of the still baby in the SCB Medical College, the affair was lodged by the brother of the victim. In the meantime, 3 examinations have been examined,
And so far as the 164 as well as the 161 and the statement of the victim is concerned, there was no sign and symptom of any any possible physical relationship. The victim herself in the doc has stated before the learned court below.
Charge has been framed.
Charge has been
Evidence is
framed.
being recorded. At this stage, you want that a cognizance order.
Preliminary charge sheet has been filed. And there is no sign and symptom of the rape. So far as the allegation of the FIR and the statement of the victim is concerned, there is no sign and symptom of rape. But the police, the investigation agency has filed charge sheet under section 37629 2N. And the ingredients of the 37629 2N is not applicable so far as my case is concerned. Again, the allegation against the petitioner is concerned. I'll have a glance at the FIR as well as the 164 statement. I have annexed all these things in my case. Kindly have a glance at the FIR.
First to 164.
164.
161 my lord, running page, no, deposition of my lord, 16 my lord.
Page
15
16.
and 16.
Page 16. The victim said
Come to page 15.
15. This is the 161 statement.
Yes.
This is the 161 statement recorded under section 161 by the IO of the victim, where it has been clearly disclosed that the victim was in love relationship with the accused person, the accused petitioner, who is before this one. That ମୁଁ 3 ବର୍ଷ ହେବ ଆମ ଗାଁର ବଳରାମ ତରାଇକୁ ଭଲ.
Yes, my lord.
No, but your prayer is for questioning of cognizance.
Revision.
Yes, only but we have given it. I'll file it.
The petitioner will select the order dated
16/1/24.
16/1/2024, whereby the trial court has
Alright.
framed the charge against for offense under section 419 in the page 5. He seeks
No, pardon, it may be converted. It may be converted.
avail appropriate remedies under law or to assail the state interest. With liberty in this case. Yes, next.
17.
Here is the case and counter case between two families arising out of a land dispute. Kindly have a glance to the FIR, page 32. That here, the complainant who said that with due respect and humble submission.
What do you want here?
Was because one of the petitioner with the son of the main accused. Allegation is against the main accused with the father. He is the son. Omnibus allegation, and I am a young boy and appearing in the for different government exams. And because of the criminal proceeding, there will be a and there is no allegation against direct allegation against me. Kindly see the counter.
You have also filed a cross case.
FIR has been lodged by our side by my brother. Your Lordship, kindly have a glance to the FIR. First, I am reading the FIR. We are challenging page 32. With due respect and humble submission, I beg to state that Mr. Kapil Lakra, I am the Kapil Lakra, and father, Mr. Bhikari Chandra Lakra, was quarrel with me. He took stick, axe, and knife, attack me and my brother, Mr. Nicholas Lakra. I am so harmful and my condition is very bad. Please take it and solve problem.
Your name is there.
Married?
Your name is there. Kapil
Yes.
Lakra.
And our FIR, kindly have a glance in Annexure 5 page, relevant page 65. My brother lost this FIR. ମୁଁ ଶମ୍ଭୁ ଲାକ୍ରା ସୋନସୋ ଗ୍ରାମ ସୋନସୋ ଆପଣଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଉଛି କି ଯେ ଆଜି 25/4/2023 ସମୟ ପ୍ରାୟ 12 ଘଟିକା ସମୟରେ ଅଲଣ୍ଡା ଗ୍ରାମ ସ୍ଥିତ ମରି ମାନସ ଲାକ୍ରାଙ୍କ ଦୁଇ ପୁଅ ଫିରୋଜ ଲାକ୍ରା ଏବଂ ନିକୋଲାସ ଲାକ୍ରା ଆମ୍ଭ ଘର କବାଟକୁ ବାଡ଼େଇ ଘର ଭିତରେ ଜବରଦସ୍ତି ଧସେଇ ପଶି ଆସି ମୋ ବାପା ଓ ଘର ସଦସ୍ୟମାନଙ୍କୁ ଧମକେଇ ଦେଇ କହିଲେ ଓ ଗୋଟିଏ କାଗଜରେ ଦେଖାଇ ଦସ୍ତଖତ କରିବାକୁ କହିଲେ. That is a demarcation filed by the informant. And
complicated facts.
No.
Cross cases. You want to segregate everything and
No, it is
one of the accused from there.
No, it is arising out of a land.
Because he is a student.
Land
His
dispute.
name is there in the FIR.
No, land dispute. Because of land dispute.
What best I can do is I can issue notice because cases are minor in nature. We will see the cross cases and all. We can try and sort it out. Issue notice.
Short date may be returnable date.
First we give you. Let us see. If they come, try to settle because the land dispute cross FIR.
But they are not, I made not made the informant as a party.
You should have done it.
We'll.
Let account for the petitioner seeks to seek leave of this court to implead implead the informant in the present case as opposite party number 3. You may do so during the course of the day, countersigned by the issue notice for the opposite party number 3.
Item 18.
Question of the proceeding on the basis of the annexure 2 minor offenses under section 362, 376 2N, 376D, 506 IPC, read with section 61 of the
376D.
Yes, 6 P1 Poxo Act minor. Kindly say annexure 2 minor.
Taken the matter 1 week after.
20.
Here I'm challenging the order of cognizance dated 3/11/2023, Your Lordship. Here is the case and a counter case, Your Lordship, all arising from family dispute, Your Lordship. And the fact of the case is that, my lord, the petitioner was
Arising out of DV case.
no, my lord, not a DV case. DV case is the counter FIR, Your Lordship.
294.
The cognizance was taken under 294, 323,
Where is the charge sheet?
my annexure 2, Your Lordship. 3 Your Lordship.
3, yeah. Yes. What are the allegations against you? Yes.
My lord. The allegation, my lord, that while they went for a compromise to their house, my lord, after coming immediately from their house, my lord, they lodged a FIR that I am assaulting them and abuse them. That is the allegation, only allegation. Right? Meanwhile, my lord, opposite party 3 has also filed a divorce petition against the petitioner, Your Lordship. And Your Lordship, the
chance of settlement.
My lord, there is scope of
notice.
Yes.
Opposite party number 2. Within 2 weeks. First week report.
My lord, I filed a IA, Your Lordship.
Shall I record that there is a chance of settlement?
My lord, that
Then
is
only I can, if there is a chance of settlement, then I can stay.
My lord, another thing I want to place, Your Lordship. Another thing I have to place, Your Lordship. My lord, another CRLMC is pending, Your Lordship, the counter case. Counter case which we have filed, they have come in a CRLMC number 1811 of 2020. 11 of 2023.
Tagged with that.
My lord, which has been also stayed, the proceeding has been stayed in that case.
Did see the order there?
My lord, it's 12/5/2020.
It is their petition. Against
My lord, no,
their petition against you.
my lord, we have given a counter case. That petition, that FIR, Your Lordship, they have come with a CRLMC.
Then you have filed, you have filed the case against them.
My lord.
That is the stay.
My lord.
Show me that order. Show me that order. And
12/5/2020.
If they say, then I'll give stay.
My lord, 12/5/2023.
Print out the calculator.
Order.
Give the number, case number.
1811 of 2023, Your Lordship. CRLMC, Your Lordship. 1811 of 2023.
Take out the order and show me. Okay.
My lord, highly grateful, Your Lordship.
Yes. 21.
My complaint case, wife and husband both are present. Then living together.
How many accused are there?
Only husband, wife has filed against the husband.
Okay. Offenses?
Offenses, Your Lordship, 294, 341, 506, 498. Having 2 children.
They have settled.
Both are present.
Staying together. Right now. At the instance of opposite party number 2, Mr. Maharaj, Nirvaj Jasa.
Yes, he said, Trinath Das, the informant, and his father Saroj Das, both are the informant, my lord, are on reserve. Bauri Vaishnav. So how 3 SCST acted?
Give a copy.
না দেইছি তো কপি দেইছি এটা লেজিবল কপিটা হজুর
ये କିଛି ଦେଖାଯାଉନି ଗୋଟା
লেজিবল কপি নিও
ହଁ ଗୋଟା କାଗଜ କିଛି ଦେଖାଯାଉନି
ହଉ ହଉ ଦେଲୁ ପରା
Verify କରନ୍ତୁ ଦେଖିବା।
ହଁ
So whatever we lost, may issue notice. I will get.
Yes.
Because it's a 3 SST, so notice is.
ଆପଣ ଏଇଟା ଫାଇଲ କର
এটা already filed he.
no with affidavit
Milord, already you have filed.
but with affidavit
With affidavit ଆପଣ ଏଇଟା ଦେବେ ନା ଏଇଟା document ଟା ଦଉଛନ୍ତି ନା
Document already annexed 2.
ନାଇଁ induce ହେବେ
ନା
ନା
ଇସିବେ
Yes. Page 14, my lord.
ତାହେଲେ ଠିକ ଅଛି ଏଟା ଅଛି ତ
page 14 ନା
Yes, my lord.
which is not seen ମାନେ we can't be seen whether this document or what which document how will I know
ଦେଖା ଯାଉନି ତ ସେଇଟା
ସେଟା ମୁଁ ସେଇଟା ଗୋଟେ legible copy will pass on.
the land council issue notice to the opposite party number 2 2 returnable within 2 weeks then council for the petitioner seeks time to file legible copy of annexure 2 or to
May I file?
substantiate his argument that the complainant in the present case is not in neither scheduled drive or
scheduled gas.
General.
Rather he is a general
Yes.
he is general
Oh, yes. Unreserved category.
unreserved category therefore the FIR filed by him per se is not tenable under law tenable under law issue notice to the opposite party in the meantime the proceeding report
no my lord no stay unless
same case
ठीक है ଗୋଟେ minute ଆଜ୍ଞା ମୁଁ କଥା କହିବାକୁ
yes.
section 15A of scheduled caste scheduled tribe act SST act is totally prohibited but it's a bar unless until they appear no order shall be passed that is the
I am just submitting
1 minute Mr. Mansingh submits that in view of the fact that the FIR itself is not maintained he would be moving appropriate application before the court below or to seek adjournment owing to the fact that the matter is sub judice before the court he may do so he may do so
Lordship may see same case and stay has been granted by this honorable court. Same issue should we see that but I am giving the copy also
যদি গোটা কিছু wrong হয়েছে সেটা
wrong what is wrong in it again 3 assist
it is stay indirect
no corrective action shall
stay indirect it is balance check now
well what happened NBW has been issued we are on anticipatory bail your lordship may see we are on anticipatory bail
where is NBW
I have stated in my petition
where is it
NBW has been issued lordship may
I'll keep it revenge till the
yes and out of my lord 7 persons page 10 lordship may have a glance to that 2 persons has been died in the meantime
পরে পতা চালা এই সার্টিফিকেট যেটা লগাইছেন সে দ্যাট ইটসেলফ ইজ ফর another FIR will be law
মাইলা
এই যে সার্টিফিকেট দউଛନ୍ତି পরে জଣା পড়িব যে এটা সেটা ବି কর তারপর আউট কেস আপনার উপরে হবে let us wait
the report of a tahsildar my lord that is the report of the tahsildar
you know what kind of certificate
certificate କେତେ forge ହଉଛି ତା ସୀମା ନାହିଁ
sir এটা যদি fraud হবো
I have given indirectly a stay only
yes
why are you worried
no corrective action
no this is not the court for no course with
my lord
go to
other court in same self issue and same village
court under 438 see tell all these things you will get it yes next
25 urgent copy
25 yes
This is the matter, lordship. The present petitioner was assured by one boy for marriage and he did not turn up. He did not turn up. Thereafter, she filed an
what is this prayer I am not able to follow
prayer.
The petitioner allowed the same thereby directing the registrar civil court
The prayer
accept the wakalatnama of the council engaged in
prayer.
Further, alternatively, the court ends of justice proposed.
But only prayer is lordship. She wanted to engage her private lawyer. Since in the FIR government lawyer are there, she found some smell, foul smell with the government lawyer because that
you wanted a lawyer who you just sent and duo.
Let's see, because the accused is
what
just
is this prayer you just
engage. Last part, prayer, first or last two
Just
lines
read-
may be considered.
Read the entire prayer.
Prayer টা তারপরে opposite party lordship against the.
ওহো ভুল হয়েছে। ওহো।
Read it. I think you have not read it and file it.
Lordship, only prayer is
Only prayer is this prayer.
কপি পেস্ট ବୋଧେ କରିଦେଇଛି ଯେ କିନ୍ତୁ କଥାଟା ହଉଛି ତା ଲୟର ଏନଗେଜ କରିବାକୁ ଚାହୁଁଛି
You do it, who stops you?
ସେ କାଉନସିଲ କି କହିଲା ପରେ ବିକଜ ଦ୍ୟାଟ ମ୍ୟାନ ଇଜ ୱାର୍କିଂ ଆଜ ସବ ଇନ୍ସପେକ୍ଟର ଦେୟାର ପୋଲିସ
Go to Bar Council of India.
ଯାଇ ହବନି
Forcing himself, no, I will appear. Can the court say that, no, you get lost and
no, government lawyer is appearing. The PP is appearing. I wanted a private lawyer.
They don't have any faith on PP. Their apprehension that the PP is getting something and not supporting them.
Read section 301.
But let's see more about.
You can assist the PP. If you don't trust the PP, write a letter to the
let's see, kindly see
prosecutor saying that I don't have
page 15. This page 15 and 16. He's serving as
you may be correct also. I'm not saying that
but this lady is going from Bhubaneswar to Barampur and she is serving as a sub-inspector there. He is threatening. This fact was brought to the PP. He did not act upon that. That's why
can the court regulate which client will engage which advocate?
Let's only say I may be permitted to the PP is not hearing to me in spite of I went to the every aspect. My private law Okalatama may be accepted. Only this thing.
How can I?
That's beyond the scope. But thing is,
there can't be a court direction to accept Okalatama.
Let's see. Only I pray. There is no fetter under 482.
Absolutely correct.
There is no fetter under 82.
PP is not acting as per you are the complainant.
I am the
You are the informant and complainant. And under 301, you can assist the PP. You don't have trust on PP. So you under 301, the court has to accept the Vakalatnama. What is wrong in it? Have you moved the application before court below? Show me where have you moved the application.
Say application order diyantu.
Read CRPC you have. CRPC you have. Take it out. 301. 300. If I'm not wrong. Let's see 301.
application ଦେବି ଏଠି କଣ ସମର ହେଇଗଲା
अरे ଦେଇଦେଲେ ସେ ତ ଝିଅଟା ଯାଇକି ଦେଇଦେଲେ
301 and 302. Read it.
Appearance by the public person or assistant public in charge of a case appearance.
No, 301 subclause 2.
If any such case by private person.
If any such case, any private person instruct a pleader to prosecute any person in any court, public prosecutor or assistant public prosecutor in charge of the case shall conduct the prosecution and the pleader so instructed shall act therein under the direction of the public prosecutor, assistant public prosecutor, if any, with permission of the court, submit a written argument.
Let's see.
This is the limited.
Let's see. Only this aspect is only to assist.
Let it counsel for the petitioner seeks to withdraw this petition to move appropriate application.
Yes.
Under I will not say the
No.
under the code. With a prayer to give him liberty to appear in the court and assist the public prosecutor for prosecuting the person.
Liberty to upon lawyer.
ନା ନା ସେମିତି କେମିତି ହବ ନାଇଁ
Upon lawyer of her own choice. Only that.
How much the lawyer will be paid? I'll decide that also. Tell me.
Let's see.
By check or cash you will pay. That also.
That is for that purpose.
Try to understand to what extent the court and 482 can go in. Engage lawyer, accept Vakalatnama, fix the fee, and everything will be done by this. This much I have given, I should have dismissed with cost. Looking into the prayer.
ଆଉ ଯୋଉମାନେ ଅପୋଜିଟ ପାର୍ଟି ହେଇଛନ୍ତି ସେଟା ମୋଟେ କରିବା କଥା ନୁହଁ cost at least କରିବା କଥା at least ଆମ ବାହାରକୁ କିଛି ପଇସା ଆସୁ
You to pay something.
Very fair. My lord, and explain fund is very fair to the bar.
So therefore go and move an application before the court under 301, subclause 2. Say that take my Bokalatnama on record and allow me to assist the prosecutor. Okay.
26.
May it please, my lord. My lords, herein the petitioners.
Yes.
Herein the petitioners have challenged the order of cognizance taken against them, where while annexed 3, whereas in the charge sheet submitted by the investigating officers, their names have been deleted. My lords, may see page number 33, my lords.
33.
My lords.
Okay.
The ongoing paragraph, last line. The FIR name accused person Kaja Ramarao and Penta Devi deleted from charge by the SO as the involvement in this case has not been proved. Thereafter, my lords, the informant, which is the opposite party number 2 herein, had filed a 1cc in the form of a protest petition, my lord, on the basis of which, but annexed 3, the learned court below, has taken cognizance against these 2 petitioners, my lords. The petitioner number 1 is a mediator during the time of marriage between opposite party number.
Again, that is on merit.
My lord.
Procedurally, what is wrong?
My lord,
See,
there is no evidence.
One particular provision is offense is wrong.
My lord.
He files a protest petition.
My lord.
The informant. And evidence is recorded and cognizance is taken. What is wrong in it?
My lords, even in the evidence which has been recorded before the learned trial court, my lords may see page 46, annexure 4.
46. Okay.
The initial statement of the complainant under section 200. My lords, here also, the entire statements recorded, she has not implicated anything against opposite petitioner number 2, except that she used to instigate the parents-in-law and the husband on phone, my lords, in order to harass her. My lords, there is
enough.
My lords, but during the course of investigation, nothing has been brought out.
That's right. That is why she has filed protest petition and brought some evidence against you.
My lords.
You argue on charge. Not in this.
But how can a protest petition be filed? There is a charge sheet. A protest petition can only be filed when there is a final report saying there is no case. And a notice
Final
is
report qua these offenses.
no notice has been issued to her, my lords. A notice cannot also be
Whereas,
issued.
show me that. Show me that. Where is the notice is not issued in
Hey, nay.
yes. Where is the proceeding?
The complaint of your lordship may look at page 37 of the complaint.
37. No,
Right.
you said no notice. Let us see.
ଦେଖନ୍ତୁ ତ page 37 ଟାକୁ ଦେଖନ୍ତୁ
37, I am there.
column 4 ଟାକୁ ଦେଖନ୍ତୁ. FIR was given, registered as such and such, numbered as such and such, but Kashinagar police filed charge sheet against only first 3 accused and discharged remaining 2 accused persons. So also police had not charge sheeted for the offence under 313 IPC even if there is material for the same. After action taken by the police had registered the case, not properly investigated. They have irregularly discharged the accused K. Ramarao and Petta Devi from the charges, even though there is material.
Loosely used word discharge. What is it?
No, I am not concerned with that. Then so also irregularly police has not taken charge under 313 IPC. Next page of the documents filed along with the complaint. Certified copy of the FIR, plain paper FIR, final form, charge sheet 161, CRPC statements, medical injury reports, etc. These should not have been filed, should not have been taken into consideration. They have not been taken into consideration. Then what she says in the complaint is
Application to the National Human Rights Women Commission and all. Application to the
that, my lords, they may go.
Yeah.
But a court is not required to look at the documents which are part of the GR case while taking
about
public.
one, but 3 or the other things are there.
Nowhere she has stated here that she has come after receiving a
told
notice.
me.
She has not stated here, my lords. Then I have to get the order sheet.
You have to get the order sheet to satisfy me that land council for the Mr. Pandar, land council for the petitioner seeks time to file further document to substantiate his case. Reach the matter on first week of 8th or 9th. 9th. Yes. 27.
May I please your lordship? My lord, Belgium matter, NBW order number 55 by dated 30/2/2024, annexure 1, page 8. Earlier, petitioner was on bail as per annexure 1, page 9 and 10 by the Lone Trial Court, Hon'Ble, Special Court.
What do you want?
My lord, Belgium matter. आगुर bail जाइथिला.
You are on bail. You tell me
Yes,
when you got the bail.
Yes, my lord, bail. Annexure 1, page 9 ने bail जाइथिला.
Give me the date. Petitioner was on bail.
সেটা করেই ছাড় দিন।
Petitioner was on bail. NBW is on.
NBW 30/1/2024
5th April कर दियो।
बेल डेट है 20/10/2022
ठीक है। हाँ सर 500 पर here allowed here 28
case under section 363. The boy and girl, they have married. Father is the
Cognizance itself is clear.
place it on record. I'll take it. File it.
I need an interim order.
It's all right. Nothing happened. Cognizance what will happen.
No, I have been directed to appear for framing of charge tomorrow.
You can seek time. Just Mr. Maharaja, just give instruction not to.
Then I am filing this only.
Actually, I have seen the entire record. My learned senior goes on arguing on the last stop. From the beginning, I have seen the record. Actually, there is no evidence. You'll also may stay the proceeding, issue notice to the opposite party. It's a case.
You've seen?
Yes, I have seen. I have seen. Not a single word has been whispered. That is why in the night I have seen how the cognizance has been.
Bring it pass over. Because I can't record his concession. Because
no, only your lordship satisfied.
Yes,
Lordship.
Miss Mehta will be there.
Yes.
Pass it over. Therefore, you should not come. You should not have come.
No. I was going to sit here.
She was doing a perfect job.
So, follow court.
Yes, 29.
May it please your lordship. My lord, item number 29. Here the petitioner challenging the order against release of cattle, my lord.
Release of
cattle. Another matter. Previously, your lordship reserved on judgment. Mr. Luthra, senior advocate, appeared. Similar situated, my lord. 29 and 35 of the Parent Act not complied.
May I please, lordship? I have been instructed to appear in this case. For the person who is claiming ownership over the cattle, my learned friend probably is appearing for Go Foundation.
Yes.
From Go Foundation? The Dhyan Foundation. He is appearing for Dhyan Foundation.
Go Dhyan Foundation.
No, it is Dhyan Foundation.
Dhyan Foundation. He is appearing for Dhyan Foundation.
You are the accused.
I am the person who has purchased the cows. I have
from the accused.
No, not from the accused. From my vendor. They claim that the cows are under their custody. The trust has it now. On the presumption that this was a cow, this was not a cow that was purchased. We have purchased it, made payments. Now we are seeking recovery of the same. Lower court has ordered for the same.
You moved the application.
We moved the application for release.
Yes. Saying release.
Yes.
How it was transported?
It was transported pursuant by way of vehicle. We had paid for the entire transportation fees. We have paid for the entire vehicle, the cows, all online transactions. Nothing by way of cash.
How the FIR came to reach it then?
Violating the 56 of transport rule.
At night when the cows were being proceeded, the local police thought that this was something that was without authority. No one had purchased it. Some cows were being traded over. That was the reason they moved on that basis. Now the lower court wanted all those documents. Those documents were placed into record.
Why quashing is not filed then?
To me?
Quashing up for the criminal prosecution.
No, we appeared for the court below. We moved there. We moved there for release of vehicle.
No, release of vehicle is one.
Not for the vehicles, for the cows only, not for the vehicle. For those 8 cows for which we have paid money.
What is your name?
My name is
How are you
Pradipta
related
Mahakut.
with- Do you related with the accused?
But I am Pradipta Mahakut, my lord.
Here, my
I
lord, the
am
police
Pradipta-
not
I did
filed.
copy of the
Are you
petition that I.
related with the accused? In the FIR?
In the FIR, yes, I am Pradipta Mahakut. My lord, the FIR copy that I take brief copy se dele.
You are the accused.
Yes, my lord. I am.
That's what I'm
Pradipta.
asking.
Yes,
You
ma'am.
said no, I am.
Yes.
Yes.
Here, you are the accused. You are the accused claiming that you had valid transport.
I have, my
something,
lord.
I purchased it
Yes.
and moved an application for releasing of
Yes,
those,
my lord.
cattle,
Yes.
which was released in your favor.
No, it has
Yes.
not been released. The order has been passed for release of the same,
That
and
is-
I have paid the money also to their respective accounts, because they said that since we had the cattle for that period, we have made some expenditure. We have paid them 43,000 earlier, and
How
subsequent
many cattle were
Eight cattle, your lordship may kindly have in one vehicle. That is a
that
violation
we have
of
done, my lord.
violation
I
of
don't
rule.
have a copy of the petition that he has filed.
For that
But
reason,
the
the
court
case
bill has passed
registered.
listed
The
orders.
idea of the act and the rule is
Right.
to prevent the cruelty.
There is no cruelty there. Well, if a lordship,
Eight
It's a-
cattle in
transportation take acid, that's for sure.
Rules
That I bow down to that.
1978, your
I'm
lordship.
not questioning all that. It's a case where had it been a case.
Cattle were injured.
No, there is no.
Medical report is not
No.
there, your lordship.
No,
I will collect
no
the
injury.
medical.
Rather, we have
If
paid.
there is injury, there is no question of release to you.
Well, that release order has already been passed pursuant to their
That I
appearance.
set aside if there is
Yes,
injury.
yes, there is no injury.
In
There is no
a
injury.
small vehicle, you
No,
transport
it was a big,
eight,
but
nine.
anyways, I will not question all that, my lord.
This is cruelty against the.
Yes. I will not say anything, but it's a fact that we have purchased.
Cattle.
It's a fact that I'm trying to get back my own cows. I have a.
What is your name?
That's Pradipta Mahakut, my lords.
Pradipta
OP2, your lordship.
No, copy. I would request for a
Do
copy.
you
of the
run
petition.
a beef business? No.
No. We have a dairy farm, my lords. We have a proper dairy farm, my lords.
Okay,
We
issue
have
notice. You accept.
we have a proper dairy farm, my lords. A copy I'm going to
Okay.
Issue notice.
Stay on the further.
No, no, there is no. Well, why should there be stay, my lords?
My lord.
It's my own
Now-
cows, my
now-
lord.
Your lordship, now my turn, your lordship. Your lordship may kindly peruse Rule 9078 of Transport of Animal Rules. Why the FIR registered, my lord? Because they violated where the cattle were transported illegally, my lord, for the purpose of slaughter. There is, the investigation
That's
is
what
going
I
on.
ask you, whether you are.
My lord, they said.
For the
for-
purpose of slaughtering or for dairy. That's the question.
It's a fact that
They say.
One minute, I have.
As I found from the rejection order of the London, release order of the London magistrate, where everything has been discussed, but so far the point raised by my friend that cruelty to the animal,
That is very
that,
important.
that has not been mentioned, that has not been taken note of. That
Yes.
whether the animal, any cruelty
Subjected to
has been,
cruelty,
yes,
subjected.
there is nothing. But
Exactly.
only one question, whether he is entitled to as an intervener to that application or not, that will be decided by your lordship. And the question is that whether the order releasing the cows in favor of the petitioner, in favor of the accused, where every document has been taken note of by the London magistrate, that is to be seen for consideration.
I'll
of your lordship.
examine it.
Yes, Lord.
Let us see that
Yes.
order judgment. Simply I am issuing.
Deeply
Yes,
obliged.
only
I
simple
request a
notification.
copy of the petition also.
Because without
I'm
stay,
filing
my
my
lord,
Maklatnama,
they will pursue
I'm
for
filing my
release
Maklatama,
of the
lord.
cattle.
No, you move.
What a copy there, what a copy.
Copy order de
My lord, your lordship may kindly pass an order till pendency of the case.
Mr. Sahu submits that he would be moving the application before the court below to seeking an adjournment owing to the fact that there was the matrix of jurisdiction before the court.
Well, the recent orders that we have received is the court had directed that you make an inspection, whether everything's on. Those inspection reports have also been filed before the court below.
Okay.
And we have, and as per their statement, that we are required to deposit money for the period that they had used the cattle, that money also has been deposited. They have chosen not to file the acknowledgement till date.
Anyway, I'm not saying anything.
Yes, sir. Deeply obliged, sir.
For
Deeply
that reason, your lordship.
Larger issue.
Sorry, madam.
We'll
That's it.
examine because there are many matters which are pending.
Those are issues.
One
Those are
matter
different
was-
issues, madam.
One matter was elaborately argued by
Mr. Siddharth Luthra.
and which judgment is reserved.
But that's a different issue where the question of slaughter and all those issues, beef slaughter and all that. This is a
Anyway,
case where I have my own establishment, madam.
Similar
It's a
issue.
matter on record.
He also claimed that I am a dairy farm.
Deeply obliged, madam.
30.
Grateful, madam.
Item 38, Your Lordship, my lord, is a bail jump matter. NBW issued by the order dated 21/2/2024, page 22, my lord.
Yes.
And he was on bail since 4/7/2012.
4/4
4/7/2012.
4/7/2012 21/2/2024 ঠিক আছে 500
May I please, Your Lordship? My Lord, this is a disproportionate assets case. Offenses alleged are section 13(2), read with 13(1)(e) of the PC Act and 109 IPC. FIR dated 29/5/2013 is against two petitioners, husband and wife, wherein the unexplained assets are to the tune of 314%. Well, the FIR is of the year 2013, and till date charge sheet has not yet been submitted.
Charge sheet submitted on that is on TDC bar 2023 after obtaining sanction. Right, CS number 39 of 2023. 39 CS number 39 that no 31.
That sheet is filed now.
Lord, I have to take instruction. Lord, kindly be adjourned to.
Simply I'm saying that the grievance of the petitioner is that the FIR was lodged on 29/5/2013. However, the investigation is still on and charge sheet has not yet been filed. Mr. Maharana appears for the opposite party submit that indeed the charge sheet has already been filed on
Right, CS number 39 dated 30/12/2023.
30/12/2023. In view of the aforementioned, no further order required to be made in the present case. The matter is disposed of with
Lord, I have a small submission to make. My Lord, we were cooperating in the investigation. There was a, my Lord, during investigation, the IO had reached the conclusion that the total the unexplained assets were to the tune of 9% instead of 314%.
whatever you have liberty, see the charge sheet. If no case is made out, to challenge that. Challenge that. No problem.
Obliged.
32. 32.
May it please, Your Lords. Well, the bail was once granted in this case, Your Lordship. Bail was granted. Thereafter, Your Lordship, some conditions were imposed.
What are the case?
Well, just with a glance over.
Where is the bail order? Where is the bail order?
Page 14, Your Lordship, just have a glance, Annexure 2.
14, 1
Page 14.
Yes.
1/4. This is the order in the BLAP granted by this Hon'Ble Court. Your Lordship, straightway go to page 16. What are the conditions? Well, got it. At paragraph 8. Let the petitioner
Go to that court only.
My Lord, I'm just sure.
No,
My Lord, I have complied with.
Coordinate bench has given this order. You have to go to that court only. I can't alter the order of the coordinate.
Because now what happened?
The petitioner has been enlarged on bail by order dated 18/10/2023, while allowing a BLAPL number 11116 of 2023 by the coordinate bench. The petitioner is agreed by the condition imposed.
No, my Lord, not agreed by the conditions. My Lord, subsequently the NBW has been issued by the London lower court.
Seek modification of the state order.
Not modification, Your Lord.
What do you want?
I have challenged the NBW issued by the London lower court because of non-fulfillment of one of the conditions.
You don't want that this order should be.
No, my Lord. I don't want that this order is to be modified because I have complied with, but in late. But in late. That is what I am trying to submit, Your Lordship. Paragraph 8, Your Lordship, just have read the conditions.
Which condition?
He shall furnish a cash security of rupees 1 lakh before the London court below at the time of his release. My Lord, no problem. I have deposited it. Second, Your Lordship, he will deposit a further amount of rupees 50,000 in the court, which will be kept in fixed deposit in a nationalized bank.
Right.
My Lord, this 50,000 I have deposited 3 days delay. My Lord, just have a glance. Next page, page 17. 1 lakh I have deposited, rest minus,
Therefore, NBW issued.
therefore it has not been.
No, NBW has been issued because it says, Lordship,
Right.
may have page 20.
Yes, just told you.
Page 20, order dated 25/1/2024, the second paragraph. On perusal, Lordship has it?
Yes.
On perusal of the case record, it is found that the accused has not deposited till date a further amount of.
He said that he deposited.
My lord, page
That is
17.
contention.
Okay, it's all right.
Page 17
All right.
placed before the
All right.
JMFC.
Right down. Only said that. But coordinating. Coordinating. There was there were the following condition very important. Condition see page over paraitri beta condition. In compliance to the first condition, the land conservation petitioner submits that in compliance to the first condition, he has deposited 1 lakh rupees at the time of release of the time of his release, whereas the 50,000 rupees he has deposited in 3 days. And 3 days after his release.
30/1/2024.
On 30
Mile.
37. The court below issued NBW wide order dated 25/1/2023, clearly stating that the
That will be
sum of
found.
rupees 50,000 directed to be deposited by the coordinate bench, directed to deposit by the court granting bail, has not been complied. Complied. Since the petitioner has already deposited 50,000 rupees, since the petitioner has already complied the condition of bail, the NBW issued on 25/1/2023 is set aside, and petition is directed to appear before the court and appear before the court on or before.
My lord,
Appear before court in the next day.
Well, let the lower court verify whether this payment has been made or not. Because this is
is
their allegation that the payment has been made. That is,
He says he is filed.
Page 17, my lords,
17.
Annexure 3, placed in the court of JMFC court
There,
part.
why should you doubt all?
Page 17.
page 17 just says it is a bank statement.
Yes, yes. It has been placed
The
before the
veracity of
JMFC.
this, let the lower court verify, and only then take it.
Nikhil Pratap.
Let the
Nikhil
Lord.
Pratap appearing for the state submits that submits that the veracity of Annexure 3, whereby the petitioner says that he has deposited 50,000 rupees needs to be verified. The same may be done by the court below to ascertain as to whether the condition of depositing 50,000 rupees has a format.
One more submission of mine. If your lordship, this 50,000 rupees, it has been placed before the court. Your lordship, if it is not, my deposit may be accepted.
If but and all, you got a bail, condition is
Mine.
there, you have to comply, as simple as that.
Well, I have
If but and all this.
My lord,
You have not paid that.
I will deposit rupees 50,000 rupees, which has not been accepted. That is, let the land.
I have recorded your statement.
Mine.
If you have made wrong statement, your bail will be cancelled, as simple as that.
What my
I will have to add that.
This, my lord, this certificate, this has been placed. This is what it has not been accepted by the London court below because it has been deposited after
3
5
days,
days.
no problem.
After
that's what I
5
say,
days.
No problem.
It has not. This may be accepted.
Yes.
This annexure 3 may be accepted. This is sole something. Only man.
I will correct it.
My, this annexure 3 may be accepted.
33. Huh? 33.
My lord, bail matter. The petitioner was on bail on order dated 28/7/2011.
28/7/2011.
And NBW was issued on 10/7/2018.
10/7/2018. How many of you are there? 1,000. 1,000.
My lord,
1,000.
34. My lord, the amount which has been in late, it has been deposited, that may be accepted. That's also. The 50,000 amount has been
You are
deposited.
making a constitutional issue now.
No, my lord, the
Small
amount,
issue, you have 50,000 you have deposited, they'll accept it, the condition is.
but the law and court below didn't accept. This same may be accepted, Khali, only that.
That 50,000 rupees which has been deposited late has not been accepted, the same will be accepted.
Only
Here,
34 Belgium, my lord.
Belgium 50.
Yes,
34.
34.
For the week. Bail?
My lord, he
You are
was,
bail?
after complying 41, he was granted bail by the police.
He was, he was on bail. He was on bail.
Madam.
Bail, NBW issued on
21/12/2006.
2006.
Yes.
So, what will be 1,000 and they appear on or before 5th. 35.
35, my lord, Belgium also.
Yes.
My lord, the petitioner was.
How many Belgiums are there?
My lord,
5.
30/5/2023, 35/2023. Petitioner was on bail as per order passed by this honorable court in BLAPL number 8298 of 19.
Give the date, give the date.
15/11/2019.
NBW?
35/2023.
500. Baki jo Korea.
Well, Arata is Belgium. Your lordship, 36 is also Belgium. 36.
Okay, fine, yes, 36.
36, my lord, Belgium. My lord, the petitioner was on bail under annexure.
Don't say annexure, give the dates at the
My lord,
start reading.
my lord, 13/4/2018, petitioner was released on bail by the court below. And
8/12/2023.
NBW was issued.
500.
My lord, oblige, my lord.
37.
7 is not a Belgium, my lord. The warrant has been issued against the petitioner, my lord. That is at page, my lord, page 22, my lord, at page 29, my lord.
Warrant has been issued.
Yes, my lord.
You are on bail.
No, because my lord, the
Wait,
injury is.
password.
Yes, my lord. 37 and 38 password, my lord.
Password, yes. 39. 39.
Well, in this case, the prayer of the petitioner before your lordship is to quash the order of NBW and to allow him to appear surrender before the court and to direct the court below to release him on bail. Because
No, then everything, then dismiss the case and everything. You are willing to appear 1 CC case?
Yes, my
When
lord.
NBW was issued, tell me.
My lord, NBW was issued on 22, my lord, 4/2/2022.
The case is arising out of a 1 CC complaint. The case is arising.
Page 4.
The petitioner is accused in ICC case number 324 of 29. Due to his absence, NBW was issued on 4/2/2022. The learned counsel for the petitioner on instruction submits that his client would be appearing before the court on or before 5th of April and avail remedy under law with so the NBW issued by the court below on 4/2/2022 is kept in avail till 5th of April.
I may be
And the petitioner is directed to appear before the
My lord, arising out of NI Act, my lord, he will surrender.
jurisdictional court and seek remedy as per.
I may
Yes,
be-
next.
I may-
In this case, on 23/11/2023, in 317 petition was rejected and.
Yes, when you are on bail.
Yes, I was on bail. I was appearing in the court.
Give the date.
Bail,
He was on bail, the petitioner was on bail. He moved application under 317 CRPC, which was rejected, and NBW was issued on 23/11/2023. He seeks indulgence of this court. The undertaking for the.
I may be pardon you, lordship. 69, I pray for an adjournment. No defect is there, I will remove the report. Oh, blessed.
6th.
601. Okay, for this.
Special note.
Special notice.
May I please, your lordship? My lord, the affair was lodged under section 363 of IPC with the allegation that the father of the victim is the informant. He has lodged affair, my lord, alleging that her daughter was playing Raja Doli, and thereafter the present petitioner came and taken away her. That is the allegation. With that allegation, under section 363, the affair was lodged.
What is the interim bail you want?
My lord, the matter was fixed to today. Notice was served on the informant, and matter was fixed to today, my lord. And the victim and her father was there in the Keonjhar court, my lord, virtual court. But just now I got information that they left the courtroom, my lord.
You said that the parties are there.
Yes, my lord. From the
Brought this matter in a special.
yes, my lord. I beg
Now you
apology,
are
my
saying
lord.
that nobody
I
is there.
beg apology, my lord. That was from the tail, my lord.
Adjourn it till the date when they will have their gracious presence.
No, my lord. Your lordship, they were
The
there.
accused should be there. The court, can't run after them.
No, my lord.
He wants bail on the condition that you have settled, and now you are saying that he is not there.
My lord,
I put it in the special notice.
my lord, I beg apology because they are tribal people, my lord. Your lordship know they are.
What to do?
My lord.
Give a date according to his. Yes.
One compromise letter.
Compromise. 70. When is compromise? Compromise matter. Item
78.
78.
May I please, your lordship?
Yes.
On the ground of compromise, your lordship, parties are present. 3 accused persons, 1
78.
my lord.
What is the offense?
Offense, your lordship, 448, 354, 436, 379, 34 IPC, your lordship. Arises out of complaint case, your lordship. In fact, there was a RSF pending before this honorable court, and which was ended in compromise 2017, and thereafter the matter has been compromised, your lordship.
I'm for the informant.
You are for informant?
Yes. Affidavit filed both parties.
Samima BV. Just see. And
The wife, even after several requests, she is not come.
Why?
And then she informed that they were not allowed to appear through VC. And I have filed the settlement agreement as well as the mutual divorce application, where it is clearly mentioned that she undertook that she will compound or withdraw the complaint filed against the husband.
He is the informant.
Yes, she is the, yes, my lords. But she informed, her advocate informed that they were not allowed to appear through VC from the Angul court.
Which court?
Angul.
Why?
I don't know.
What is it? If the High Court says that you appear through VC, which court will
No,
say
notice may be issued. I think that would solve the problem.
You say that. Don't blame the.
No, I'm not blaming at all. They informed us that they were not allowed.
They should not have gone there.
Maybe.
Maybe. So
There is every possibility, my lords.
Opposite parts.
Yes, my lords. We called them several times. They did not respond.
Returnable next week?
Yes, your lordship.
Next week. And later come from Angul.
Yes,
what is the problem? In her
Deep
absence, we can't.
Yes.
Yes, your lordship. Deeply obliged.
Thank you.
Only passports.
Only passport.
Item 1. Yes, Mr. Nando, we are waiting for week.
No, my lord. 42 passports.
So
I'll wait for passport.
Item 1.
Item 1. Just one.
Item 1. Budget. 26.
Yes, madam.
Yes.
The same matter.
Yes, sir.
Show me that.
You should come to page 45.
40?
45. They bid it 45. We'll also got it. 45, last 3 lines. It has been observed on the above. It has been observed. Yes, last 3 days. Therefore, due to lack of a prima facie evidence under section 313.
On perusal of the complaint, petition.
No, just above, just above.
Okay.
First paragraph, last 3.
Okay, okay.
Right.
He has also
Right.
did not take to the name of any medicine. Where is that?
The complainant has also not stated before the court. You also got it. That's your lordship was reading.
Yes.
Court, so how she came to know about her pregnancy and how many months she was pregnant at time of the alleged miscarriage caused by the accused persons. She also did not state the name of any medicine which was allegedly forcibly administered to her. Therefore, due to lack of prima facie evidence under section 313 of IPC against the accused person, this court is not inclined to take cognizance under section 313 of IPC against the accused persons. Then only 498A 506 34 IPC cognizance is taken. Even the accepting that evidence is there, Lord, the complainant stated it page 47. Page 47. Para 3. The name of the petitioner is defined place. The maternal uncle of my husband, K. Ramarao, the petitioner, my lord, has knowledge. You also got it?
Where is that?
Para 3, page 47.
Okay.
Para 3,
K. Ramarao
my lord,
has knowledge about
medicines, and my husband and his instruction without telling me administered me those tablets due to which I miscarried after 2 days thereafter.
medicine was not known.
The 313 that is why.
So simply I will not say anything on the issue.
Only issue notice.
Issue notice to the opposite party, returnable within 2 weeks in the written exam, the proceeding before the court. So it states.
37.
Urgent certificate.
Everything is urgent, don't worry, you will get it. Yes.
37.
Like here I am challenging the prosecution under 307 of the IPC mirror, along with the order dated 27/1/23 wherein the warrant has been issued against the petitioner. That is at page at page 29 annexure 4 series page 29
You are agreed by what?
That prosecution under section 307 is not made out against the petitioner, along with the order dated 3/1/24 the imbue was issued against the petitioner. 37.
Okay. 3/1?
3/1/24 page 29
20?
Page 29 the case is put up today on pair of the IO issuing imbue against the petitioner, namely Satyendra Naik so on the ground stated there in so that case diary, up-to-date case diary and the connected police paper have been submitted by the IO. Even the FIR, up-to-date case diary and connected police papers are available in the case records. Prima facie allegation or section 3.
You are absconding, so therefore.
No, not absconding, my lord. Pending investigation, my lord. The IO prayed for issuance and imbue, my lord. Can you don't have annex the injury report of the injured my lord paste annex?
Anyway, I am not going. I will stay the NBW, go and appear before court.
But 307 is not made against petition. And other
at the stage of framing of charge, you argue all this.
No, the principal accused who asserted the murder injured, he has given bail by the non-court below, my lord. And I am the father of the...
not a bail court.
That I know.
Therefore, I will protect you.
My lord.
For 15-20 days, you could a bail remedy.
Lordship, their anticipatory bail has already been rejected in both
I
cases.
know that. That is the reason for it too.
I was just pointing it out.
That is the reason for it. Anticipatory bail would have been there.
I'm not hiding that.
I will stay the NBW for certain time. Go and.
You also need to one time.
Yes. Right now. On the application of the IO. The
first and second one, not
JMFC Bolangir.
JMFC no Bonaparte.
Bonaparte has issued NBW against the petitioner by the order dated 3/1/2024. The petitioner is agreed by the state. Without going into the merits of the case, on the basis of the statement made by the counsel of the petition of the bar, his client would be appearing before the court of public jurisdiction, not before. On or before 25th of April?
Yes, my lord.
25th of April, so the NBW issued by the JMFC Bonai.
Bonaparte, my lord.
JMFC Bonaparte.
Yes, my lord.
By the order dated 3/1/2024 in GR case number 79 up to 2023 is kept in advance till 25th of April 2024 with the direction to the petitioner to surrender before the court of competent jurisdiction and avail remedy under law. 38 is observation the petition is closed.
Yes.
38.
Next, my lord, same another, my lord, that order dated 3/1, same, my lord, same order, my lord. Only GR case number has to be changed, my lord.
GR case number 39.
Yes, 38, my lord.
See. 41.
No, GR case, my lord, just a minute, GR case, my lord, 82 of 23, my lord.
He'll check. GR case 41.
Page 47, my lord.
41.
41 interim bill, my lord. Given the instruction, you lost my candidacy.
Huh?
The instruction I have given.
Yes. What is this?
But his
Father of the-
father died.
The uncle of this.
Yes.
Uncle of the petition.
So that this is a matter.
Uncle is the one daughter only.
You lost
Only daughter.
clause 6. Clause 6. Ashok
Ashok
Bhoi
Bhoi
has, yes,
only
Ashok
one
Bhoi is the
daughter.
deceased. Ashok Bhoi has only one daughter, namely Shruti Bhoi. So he is a lady. So the petitioner is the only person who can perform the funeral ceremony.
Last side.
Yes.
Last side, yeah?
Yes.
But he has moved application. Which item is this? 41. 41.
41.
So many accused.
Only petitioner one, my lord.
He
Petitioner or one. Premchand Bhoi.
Premchand Bhoi.
Premchand Bhoi only.
Well, his uncle died.
Uncle expert.
Where is the interim of application?
In this case, my lord, 264 of the.
Yes,
264.
IN number 264 by 2024.
Petitioner is accused in so and so. Petitioner number 1. Huh?
Petitioner one.
Yeah.
Petitioners are accused in so and so. Yeah? This is an application moved by petitioner number 1 for interim bail.
Yes.
Interim bail. On the ground that his uncle who is recently expired.
Yes.
No, he on the ground that he being the only son, the only male member in the family.
Yes.
Male member in the family, he has to carry out the last rites of his uncle who has recently died. Therefore, he needs he seeks interim bail for a period of 1 month.
Yes.
For a period of 1 month. The factum of the death of the uncle of the business was verified the IIC
Burla place.
Burla PS at Sambalpur has submitted a report which is taken on record. As per the report, the fact mentioned in the application and applications are verified and found to be true. On the basis of the same instruction, the petitioner is the application is liable to be allowed. The petitioner be released on bail for a period of 1 month from today, 1 month from the date of
From the date of release.
date of release. He shall furnish personal bond of 50,000 and 1 security of life amount to the satisfaction of the trial.
Oblige, my lord.
And he shall surrender before the court and not leave the jurisdiction of the not leave the jurisdiction of Budla police station.
And he'll also be kindly keep it here on 15th April. And 1 month was the 13th.
15th.
Yes.
Leave the matter in 15th. Yes. 42.
My lords, my please, your lords. My lord, here the FIR was lodged under section 276, 468, 483, 486 and 326 for the purpose that he was selling counterfeit drugs and for which after consumption the DM supposedly fell ill. So he gave a complaint, the inquiry was made and he has been in custody since 30th of November. And in the meantime, the charge sheet has been framed so far as he is concerned and 326 has been dropped, which is the main my lord, allegation against him. And he is a retailer.
and all the documents, every my lord, material has been seized from him. I have given the charge sheet, if your lordships, the original, the certified copy. Your lordships may see the last but 2 pages. I have marked
You are in custody since?
30th of November 2023.
The DM has consumed.
The DM supposedly consumed after 2 days the Pantocid DSR, which is a antacid drugs. But the police, while submitting the charge sheet, has said that it cannot be confirmed because the doctor also said we don't know what he might have consumed earlier. And with this medicine,
What is the recovery?
recovery is those 6 strips of the same medicine, which along with the receipt from the stockist. Stockist has also been raided. He has
6 DJ sample taken.
Yes, ma'am.
Sample is taken, but what is the recovery?
Recovery is those 6 strips
7
of the medicine. 7
No,
strips.
10 strips of something, then 10 strips, then 7 strips.
No, these are under different batch numbers. A particular one batch which was
You are the proprietor of Ganpati.
Ganpati.
No, man. Sri Jagannath Agency.
No. I am the retailer, the retail shop from which it was purchased. Lord, I'll just, that is Ganpati. Ganpati is the wholesaler. And
You are proprietor of the company.
Lord, the
Mahabudhi
Mahabudhi medicine store.
You are the
petitioner and Alabama, another co which both are the proprietor.
Proprietors. This
Mahabudhi
medical store.
Medicine store, my lord. The collector, my lord, district magistrate, purchased the medicine from this petitioner store, my lord. Thereafter, they became ill and admitted in Apollo Hospital. Thereafter, my lord, the collector, the highly complaint, my lord. Thereafter, my lord, the special task force, my lord, constituted and accordingly the case in inquiry into, my lord.
Accordingly, what is recovered from them?
My lord, recovered, my lord, 6 strips of, my lord, the
That particular counterfeit.
and that data is sent for the state laboratory and so also the original company Sun Pharma, my lord. There they stated that it is counterfeiting, not their medicine, my lord. That are the also report came forward that it is spurious. And if one person consumes it,
No, my lord, your lordships may read that I have marked with
Not only
pencil
certain
last but
injury,
2 pages.
external injury.
The second page, if your lordships would come to last but the earlier page on the left side, my lords.
Yes.
If your lordships would just read those pointed places where I have marked it with pencil, it clearly says that it cannot be verified.
The opinion is enclosed here with during the investigation. No, it is attracting 326 could not be established. The record, hence 326 is not applicable.
Yes.
326 is
326 has been dropped.
dropped.
And clearly the doctor's opinion said he was hospitalized for 2 days, but whether that was because of this medicine or anything.
Pentoside, huh? Pentoside, yes.
Pantocide.
yes.
The spurious and counterfeit, it has.
It has, but that was on the basis of a receipt which is matching with the stockist receipt, which the stockist had given me. That is also, my lord, mentioned in that. It matches whatever the receipt I have shown is the same receipt which is on the basis of which the stockist has transferred the stocks to me. So the counterfeited is not at my end or at my place.
Who is stockist? Stockist is?
Stockist is that
Taberi agency.
Taberi agency.
They purchased
They sold it to Ganpati Enterprises, and from Ganpati Enterprises is the local stockist. From there, I took the medicines.
Okay.
In fact, my lord, what happened is, though the case listed 3 times, my lord, but at the prayer of the petitioner, my lord, 3 times adjourned, my lord. Case diary was not called for, my lord. My senior, my lord, submitted.
Case diary is there?
No, my lord.
charge.
No point of time case is called for since the advocate of the petitioner taken time, my lord. My last occasion, my senior appear in this case, my lord. For that, on that day also they sought for adjournment.
No,
And
I
she did
didn't,
not-
I
My
didn't sort,
senior my lord submitted the.
I did not seek
Charge
for
sheet to be
adjournment, but because of there was certain issues regarding the Vakalatnama, which was earlier filed.
These things are.
Lord,
Yes,
Now place it on record, get the case diary on 19th.
Man,
19th. But
he-
he's
he-
not the stockist.
Yeah.
And
This
stockist is someone else.
And charge sheet.
Ganpati is in between.
thereafter it comes to me and the receipt matches
Only
Yes.
6 trips.
Only I have to obtain the.
6 trips.
Get the case diary. Without case diary, it is not fair.
All right, 19th, your
Get
lord.
this case diary. All for case diary 19th.
Obliged.
47. Any co-accused in this, Mr. Nanda's case, any co-accused granted bail?
No, man.
All of them are inside.
My lord, this petitioner said others are absconding, my lord, and one of the co-accused, my lord, filed a application for it to do, that is day before yesterday, before this one court, my lord, and for quashing of the cognizance.
Because anticipatory bail might have been rejected.
Rejected.
Yes.
May I please, Lordship? Your Lordship, in the earlier, your Lordship directed me to file the witnesses so far examined. Because it is offense out 302 and both are belong to the tribal people, husband and wife. Your Lordship, kindly see the order of the learned district and session judge, who is rejected on the basis of the evidence of eyewitness man that Bayani Singh.
What do you want in this case? Bail?
Bail man.
Yeah,
You
they have
also
not received what about the, my, upon the
What the Devi?
they have given the documents.
Entire case diary I have annexed to the bail application. Still then this.
Have you gone through?
My lord, I have to obtain the
Get the
case.
case and
Case diary already called for 15-2, my lord.
bring the case. Every case diary and yes. 48.
I had my lord, if not.
No, it's all right. Tell me. Colleague भी ये pressure हो. Aji, if you can finish it up little early, we can see how many matters are there.
4 petitions are there. Some of the council.
It will take some time.
Take some.
Maybe, some.
95 other offences are there, my lord.
Then list it on 18, 19. 18.
18th cut.
Yes. 49.
49, my lord, prepond 1 week time, my lordship. Next year, lordship.
Yes. But 50. Yes.
May I please, your lordship?
Yes.
Lordship, I'm in custody since 12th of August 2023. Previously, Honorable Court has directed for the up-to-date CD. The up-to-date CD was called for.
CD was called for?
Yes, my lord.
CD is there?
Yes, my lord.
Yes. Tell me, what is the case?
Lordship, previously the offense allegation.
4B, 498A. Charge sheet has been filed?
Yes, 306. Yes, my lord.
Yes. What are the offenses now? 498A?
304B, 306.
306. Your husband?
Yes, Lordship. Lordship, the complainant here is the father of the deceased, and the fact of the case is the petitioner demanded 50,000 rupees as dowry money. And from the father of the deceased. Then the father of the deceased denied. Then after that, quarrel occurred between the petitioner and the deceased wife. Then after that, on 8th of August 2023, she hanged herself in the bathroom. In the FIR, the complainant stated that the petitioner and his brother killed his daughter and hanged her daughter. Lordship, may kindly turn to the.
My lord, your lordship may allow to me just read the relevant portion of the investigation. My lord, the earlier whatever may be, this acute petitioner has got married to the deceased by way of love, my lord. And after getting married, my lord, after some days, However, due to the love, Puja Behra and Ganesh Patra got married at the Maruda Mandir of Mathura. As per Hindu customs, during the marriage of the family members of Ganesh Patra attended, but no person from Puja family attended the said marriage. After marriage, Ganesh Patra took his wife Puja to the Godam Sahi Basti, Barmunda, and stayed along with his other family members. After some days, Ganesh Patra remained unarmed as nobody invited him to driving vehicle. It is his earning of source is only to drive the auto mile. So he chalked out a plan to purchase an auto rickshaw. So he started torturing to Puja, deceased woman, by demanding dowry of rupees 50,000, gold and other household articles from her parents. One day Puja called her mother Manjari Behra over phone and told the demand of dowry, and Ganesh Patra also talked with the mother of the Puja on the phone call, but the Manjari Behra denied giving any such dowry as she had already separated from Puja for many years. The Manjari Behra intimated the fact to her first husband, the Santosh Behra, the father of deceased. And though the one Jaga Jena, a relative who is staying at the Surat, on this Santosh Behra also denied to give any such demand because they were not agree with the marriage proposal of Puja with Ganesh. Thereafter, this Puja Behra indulged in the frequently quarreled in the house, which was witnessed by the street peoples. There are 161 statements.
Puja is the
Victim. Yes, my lord.
Yes.
And on the previous day night, the day before occurrence, my lord, the previous day night, my lord, of the day the occurrence, there was a quarrel between the Puja and the Ganesh, for which Puja was starved for that night. On the subsequent day, that is on the 8/8/2023, again quarrel took place between Ganesh and Puja, this victim and the deceased. But no other person was present in the house. Suddenly, deceased Puja Behra got annoyed due to the torture, and on that day, between 1 p.m. to 2 p.m., she rushed into the toilet and hanged herself. So there is the torture part is there, my lord.
So 306.
Yes, my lord.
Lord, so my question is
Demand of dowry and the 4 DP and 306.
Lord, so my question is, where is the allegation of abetment to suicide? Whether the quarrel between the husband and wife is amount to abetment to suicide? That is my submission here also.
That this is the amount of torture in the sudden and the
That's-
immediate succession you have done in the same day.
Deceased
Previous
became
night also you have quarreled with her, and she had not taken anything in that night. Next day again you quarreled, and therefore she
Learned
gets
counsel.
extreme.
Learned counsel for state.
You are in custody since?
I'm in custody.
13/8 case only, my lord.
13/8 case.
April 1st week ro. Wait for that.
How? Marriage.
No, then why can't? What is the stage of the now charge sheet is filed? Charge and everything is framed.
Charge was not framed.
Making to take instruction get this phase of trial. You must not keep it on.
Right. What I was thinking is informant till the informant is examined. You dispose of forever. You seek instructions. What is the stage of the trial? First to yes. 52.
May I please, my lord? The petitioner inside the jail custody since 9/1/24, my lord. There was a love affairs between victim and a petitioner, my lord. The Law and Trial Court, while rejecting the bail application, has opened that page 12, my lord. Kindly peruse page 12. Further, on the perusal of the statement of the victim and recorded under section 161 CRPC, it reveals that she had a courtship with the accused Vikas Malika, and as she was tortured by her family members, she requested him to take her. It is fact, my lord. She voluntarily left the house of her father, my lord.
Where is that statement?
Yes, my lord. The 164 statement.
164 is there?
Yes,
yes, my lord.
Read it.
ମୁଁ ତା ଅମୁକ ତାରିଖ ରାତି ଏତେଟା ବେଳେ 7:30 ସମୟରେ ଆମ ଘର ଦାଣ୍ଡକୁ ବାହାରକୁ ଆସିଥିଲି ସେ ସମୟରେ 3 ଜଣ ପୁଅ ପିଲା ଗୋଟେ ବୁଲେଟ ମୋଟରସାଇକେଲରେ ଆସି ମତେ ନେଇଗଲେ ସେଇ ପିଲାମାନଙ୍କର ନାଁ ହେଲା ପିଣ୍ଟୁ ବିସ୍ମୟ ଆଉ ବିକାଶ ଦିସ୍ ପିଟିସନ ବିକାଶ ସେମାନେ ଆମ ଗାଁ ମଙ୍ଗରାଜପୁର ନିବାସ ଅଟନ୍ତି ସେମାନେ ମତେ କୋଉଠିକି ନେଇକି ଗଲେ ସେଇଟା କାହାର ଘର ମୁଁ ଜାଣି ନାହିଁ ସେମାନେ ମତେ ଗୋଟିଏ ରୁମରେ ରଖିଥିଲେ ସେଠି 2 ଜଣ ମଧ୍ୟ 2 ଜଣ ମଧ୍ୟ ଜୟନ୍ତ 2 ଜଣ ମଧ୍ୟ ନିଯୁକ୍ତ ପୁରୁଷ ଓ ତାଙ୍କ ପତ୍ନୀ ରହୁଥିଲେ ସେମାନେ ମତେ ଖାଇବା ପିଇବାକୁ ଦଉଥିଲେ ତାପରେ ତା 7, 12, 23 ଦିନ ପୋଲିସ ମତେ ନେଇ ଆସିଲା This much.
There is no.
No
sexual,
no other any illegal allegation is there.
But fact that the three of them have taken, where is law of affair, where is that anything is there?
My lord,
161.
CD just right now I received the
Just take it up. If they were having relationship, we'll let him go. Show me something from record.
161 next. 160.
देखो
Record.
देखिए just दिला देखिए 164 to 161 पढ़ी दिल पर 61 का सर कुछ
अब देखिए तो I'll keep it on Monday. Monday जाए रहो तो you
Yes,
get
Monday.
the bill. Yes.
55.
ये देखिए तो बेटा को. If there is love relationship, if there is no sexual assault, the 3 boys have taken her and made it to stay in somebody's house, whereby the lady member was also there, and there is no allegation of sexual assault.
Se 2 jone bail jayse other 2 are already released on bail by the learned trial court. Who
3 of them have taken, then
who have accompanied them, they have already released on bail.
then no, 3 nahi. The 164 statement says in bullet 3 boy came including this,
Yes, ma'am.
and they have taken.
But in 160%, she has not alleged any sexual harassment.
Therefore, then if the other 2 persons have already got the bail, why not they?
Yeah, no, sir.
नहीं ये पास
Because yes, she has not alleged any 161.
Nothing.
Yes, ma'am. Yes,
Nothing.
yes,
So
ma'am.
what's the-
Right up.
जाओ
Right up.
Yes, and in the meantime.
Which item? That was?
Charge sheet has been filed.
Charge sheet already been filed, my lord.
55. 55. Okay, 55. The petitioner is accused in such.
May I please?
The allegation against the
55.
investigation charge sheet has already been filed.
Yes.
The statement of the victim under 164 CR20 has been recorded. He inter alia. Yes, he inter alia stated.
Yes.
कौन कहे 164?
164
Yes, ମୁଁ ଏତିକି ଆମ ଘର ଦାଣ୍ଡକୁ ବାହାରକୁ ଆସିଥିଲି ସେଇ ସମୟରେ 3 ଜଣ ପୁଅ ପିଲା
He
ଗୋଟେ
inter alia stated 3 of syrup.
My lord, the first offender, there is no allegation or antecedent, my lord. And the
21B.
The current phosphate amount is 336.
below commercial.
The commercial quantity is 1.
कितने bottle?
168 bottles of phosphate.
No, petitioner is accused. At the 100?
168 bottles of cough syrup
168 bottles of cough syrup were recovered
having
from
336 gram of codeine phosphate.
having 336
gram of codeine phosphate.
codeine phosphate.
This being a small quantity below the commercial.
Taking into consideration the amount of contraband.
Yes.
Seized, granted.
And is to appear before the AC because investigation is going on.
Investigation is going on. The petitioner has to cooperate with the investigation. Non-cooperation of investigation or violation of bail condition will entail cancellation of the public. Outsider तो नहीं?
No,
Local. Local. Okay, thank you. Thank you.
Item 65.
Not